Happy Sunday. Happy Sunday, jerks. We're here. We're live. Just like a minute or two late. Not too bad. Pretty much on time. I have a special guest here tonight. First time guest. Somebody who's been posting on Twitter quite a bit for a number of years now about the Karen Read trials. And she's an attorney. She's a civil attorney. She's admitted to the bar in her state. She's also been in federal court. She's been, I forget what you call that, but she's been admitted, I guess, to federal courts. She's a civil defense attorney for corporations. She recently did this FOIA request, this wild FOIA request, and then sued the Massachusetts Department of Transportation, the MassDOT, and unearthed a bunch of new documents about the Karen Read trial. One of them we used for the thumbnail tonight. You can see Yuri Buchanan doing the Welcher, doing the Smurf thing on the car without the paint. That was new to us to find out that Yuri also did the experiments on the car. I'm excited to have her on the show. Let's bring her up and let her introduce herself, tell us about herself. This is the first time I think a lot of people are going to see her on the screen. It's kind of exciting. It's like Mazza Media, like you get to see somebody for the first time, hear them, talk to them, somebody that we've seen behind a Twitter account. And a lot of us have liked what we've seen over there, what's been posted. So let's bring her up on the screen. Welcome to the Young Jerks for the first time. I'm pretty sure she is a regular chatter too in our chat here and a lot of YouTube shows. Welcome to the show, attorney Corri Hopkins. I hope I said it right. Is that correct? Did I get everything right?
You nailed it, Mike. Nice to meet you.
And we should say the name of your YouTube, not YouTube, your Twitter account. We say the name of your Twitter account so I don't screw that up too.
Marbury v. Mad, which is sort of a play on the fairly important rudimentary court case from 1803, I believe, that establishes the principle of judicial review, shortened to MAD, just because I'm getting increasingly angry on Twitter as I was watching all of the Karen Read trial one unfold. I thought Marbury v. Mad sort of described it quite well, how I felt. Plus Nunya, because at Nunya 9877, bunch of sevens, because none of your business is how I felt about it originally. But obviously, I've been posting for a long time related to the Karen Read trial, so I had to take matters into my own hands recently, and now I am no longer anonymous, which is fine by me. And here we are.
Absolutely. And it also, I think that is a good one too, that handle for Aiden Carney and Turtle Boy, because every time we have Attorney Bradel on, he always reminds us that this may go to the Supreme Judicial Court, not in Massachusetts, but like the top Supreme Court of the land, I think he says. So it's kind of interesting that it applies on that one too, doesn't it?
That's right. Yeah, there we go. I've got Georgia Kappelman as my profile picture. She's a prosecutor in Florida. She's been doing the Adelson Markel prosecutions for the last 5 or 6 years. I love Georgia. She's so witty, so smart, so sarcastic. I just love everything about her. So that's my picture.
And I hope people, I'm going to put it in the chat too so people can follow you on Twitter. Make sure you follow Corri's account there as well. Tell us about this FOIA request and the lawsuit. Actually, before you do that, tell us about yourself. People want to hear more about you as much as you want to share tonight in your background before we get into the FOIA stuff.
Sure. High level, I'm from North Carolina. I went to Duke for undergrad, and then I moved to New York, where I lived in the city for a really long time, working in the film industry. I worked in film and locations for about 10 years, and then I went to law school back in North Carolina. And now I do civil defense litigation, business litigation, class action defense, trade secrets defense, and shareholder derivative suits. So I do civil law. I don't do criminal law. I have never been a criminal defense attorney, prosecutor, none of that. So when I got into sort of the Karen Read obsession, I didn't know that much about the law beyond what you need to know to pass the bar. But I did my research. I became increasingly obsessed with the Karen Read trial and Massachusetts criminal law. And now I know far more about it than I ever wanted to. So here we are. So I work all the time. I bill around the clock. I work 7 days a week, and somehow I could not let the Karen Read trial go. And I just had to get sort of immersed in the Massachusetts nuances. And that is part of what led me to the Massachusetts public records law in the first place.
And you chose something that was I thought was interesting, and you got documents, which I was kind of surprised. You went through the Mass Department of Transportation, the Mass DOT.
Yeah, which is random, obviously. But throughout the trial, people have talked about the lack of a crash report and lack of documentation related to sort of standard motor vehicle accidents. No one seemed to have any of those documents or provide them. So obviously, a lot of the news sources, NBC 10, as we've seen recently, were pursuing the Norfolk District Attorney's Office for documents like the Morrissey email, sort of the juicy stuff, a little more obvious. And I thought, it's possible that no one is approaching it from this angle. Let's just try a different angle and see if we can get the crash reports or whatever might exist. So that's how I sort of got into it in the first place.
And they didn't give them to you at first, right? You filed a FOIA. When did you file this FOIA, and how did the process go from there?
Yeah, so FOIA, which is a fine term to use, that's the federal version of the sort of public records law. In Massachusetts, it is called the public records law. And I got to say, I really like the public records law in Massachusetts. It's very broad. It's very forgiving for requesters, and it can make life difficult on the agencies and municipalities that have to respond. The problem, of course, is that the agencies, in some instances, may not care what the public records law actually says. You have to go to court. Now, courts in Massachusetts do enforce the law. They enforce it fairly strictly, at least once you get to an appeal. So when I started down this road, I thought, if I have to bring a lawsuit, which I don't want to do because it's very time consuming, expensive, not very lucrative to say the least. But if I do, and if I don't win at the trial court level, I'm going to win on appeal. I write appellate briefs all day long. I will be happy to take it to an appellate court, but because I know that those courts are very, very forgiving and they do enforce the law, it's just the hope is that you don't have to take it that far. It's to just have the agencies apply this very broad law. And that's all I was really trying to do in the first place.
Excellent. And so they didn't do it at first, and then you filed a lawsuit. How quickly since you filed the lawsuit did you actually get the records?
72 hours, which is insane. I thought that was actually wild. Should we pull up the complaint and look at the request?
That
would be helpful.
The wrong one.
Oh, I can pull it up.
Oh no, I can do it.
Okay, great.
This is the one, right?
That's the one. So this is the complaint that I filed. And then if you could just go a couple of pages to the screenshots. Couple more. Couple more. You got this. 4 or 5 more pages then.
Okay. Keep going. Slide 8.
Next one.
One more.
There we go.
All right.
So this is the first request that I submitted to MassDOT. And the website is really easy for submitting requests to DOT. They have a portal. You just type in your information and type in the request. For this particular request, I uploaded a PDF, 1 page, this document, asking for very, very specific things. I wanted the crash report, a fatal accident notification report or notice, which is in Massachusetts is a specific document. The immediate threat report, if any, that's a document that relates to suspension of licenses after some sort of motor vehicle incident. That is a very general way of explaining it, but it's a specific type of document. And then the citation related to this alleged event on January 29th, 2022. So some very specific documents. I wanted every version of those documents, and I wanted any email communication related to those documents for a very broad time frame. So I submitted this request, and I also submitted questions with it. You can submit questions to these agencies. You can't appeal if those questions are not answered. You can't appeal on the grounds of those specific questions, but you can ask them. And so I wanted to ask them because I wanted to be able to narrow down the request that I was submitting. So I just asked, was there a crash report? Who submitted it? Was there a fatal accident notification report? Who submitted it? Basic, very basic. So I submitted this on March 23rd, which was about a month before the trial started. I'm sure it was right after some pretrial hearing that enraged me like everybody else. And I just thought, I got to do something. There's not much that you can do in this situation. You just have to watch it play out. But public records is one of the few instances in which a sort of unrelated party can get involved and at least try to help, because obviously the defense was facing some terrible rulings, and they were drowning really in all of these rulings that were going against them and shouldn't have. So I'm sure this came right after a ruling. It was the same week, I think, that the court denied the defense's motion to dismiss and the motion to granted the Commonwealth's motion to exclude Michael Easter, which is probably the decision that I hate the most out of all of the pretrial rulings that I hated, which was most of them.
It was so bad.
So
That
bad.
was so bad.
I'm not over it in the least. And in fact, a part of my lawsuit focused on that particular decision and essentially trying to use it against the courts because it was so bad to say, all right, if you're going to make this sort of a terrible ruling, then as a result, you cannot keep investigative materials hidden, because you said, Judge Bev, that everything related to the investigation was in the common knowledge, common sense of the average juror. Well, then it can't be kept secret. It has to be disclosed because we all know it, right? We all watch, Law and Order, whatever her justification was for saying that this was for excluding Michael Easter. But I digress. So I submitted this request in March. The DOT responded right away, fairly quickly, and said, we got hundreds of thousands of emails came up in response to your request, which I'm not sure how I feel about the accuracy of this, but whatever, that's what I'm stuck with. And they said, could you pare back your response in any way? I responded immediately, Mike, probably within the hour, definitely same day. And I said, sure, I don't want them over the 3-year period. I just want emails from a 6-month period. That should, in theory, significantly reduce the requests. I never heard from DOT again. They didn't respond to that email. I sent multiple follow-ups. They didn't respond to any of them. So I submitted this request on March 23rd. The agency has 10 business days to respond to a request. They do not respond at all. So we get to May 3rd, which is a month and a half later, and I submitted 3 more requests asking for just these specific documents, not all of the emails that come with them, but the documents and the emails within like a 2-day window, just keeping it very tight so they couldn't say that they were overwhelmed or anything like that. I don't hear anything until May 14th. So that's almost 2 months after my initial request. May 14th, MassDOT denies all of the requests at once. And they deny it on the basis of an exemption for investigative materials, and specifically cite the criminal trial. And I thought, well, okay, fine. I will accept.
Wait till after.
Yeah, there's a criminal trial happening, but in Massachusetts, once you get a denial from an agency, you can appeal the denial to the supervisor of records. So I thought, I'll just see what this appeal process is all about. I appealed it. I wrote out an explanation for why I thought the investigative materials objection here was nonsense, because it is, but I can explain that later. But I appealed it, and that was, I guess, May 14th was the denial. A few days later, I appealed it. Then on June 9th, the supervisor denied the appeal. So June 9th, and denied it on the basis of, again, the criminal trial. So June 9th is about 10 days before the end of the trial, before we got the verdict. So I thought, okay, I'm not going to do anything with this. I will wait, because the supervisor denied my request, but said the status of this could change based on the status of the criminal trial. Great. So on June 18th, we got a verdict in the criminal trial. Very exciting. I think it was around like 3 o'clock in the afternoon or something like that. Within 30 minutes, I resubmitted all of these requests to the supervisor and said, remember how you said that if the status of the criminal trial changed, that you would reconsider? Let's do that. And the supervisor said, great, we will consider. And I thought, things are looking up, that we are headed in the right direction. But for good measure, on the same day, June 18th, day of the verdict, I submitted another request to DOT that was essentially the same thing as this request on the screen, but about a 6-month time period for the emails. So I just wanted to cover my bases in case the supervisor did something crazy. I've given MassDOT a chance to rethink their original request as well. So all of that is pending. Then on July 11th, we are almost a month after the verdict. July 11th, the supervisor denies all of my requests for reconsideration, and MassDOT denies my new request as well. And all of them cite, actually, if you could go a couple pages forward to, I can do it. Okay, I'm going to do it.
You want to do it?
Yeah. Okay, here is the July 11th decision from the supervisor on my first 4 requests. And they said, although the criminal litigation referenced in the June 9th determination has been resolved, this office has reviewed the trial court's docket. I don't know what that means. The trial court's docket, every trial court's docket in Massachusetts. It's kind of silly. The trial court's docket, and verified that civil litigation relating to the records at issue in my request is active and ongoing in the Plymouth Superior Court. And then cite the caption for the wrongful death suit against the Bars and Karen Read. So in light of the pending matter, I decline to opine at this time. Again, with this, if there's a change in the status, this could impact the applicability of our objection. Well, okay, so there is an exemption for active litigation, but it's not a very robust exemption. So I got this and I thought, okay, that's silly, but well, let's see what DOT says. Well, the same day, DOT also denied my request. And this paragraph starting, please be advised, your request seeks information that's currently exempt under, again, the investigative materials exemption. But the last sentence of that paragraph is the key to all of this, I think. DOT says, we have been advised that at this time, the records cannot be released because of the open investigation related to the ongoing civil trial. Okay, Mike, I got this after Hank Brennan has already released his stupid little statement saying that that the evidence pointed in one direction only. We heard Buchanan testify, one direction only. The Commonwealth has been consistent from day one that they only investigated Karen Read and the evidence all pointed in that direction. Well, that's obviously incorrect because the jury found otherwise. But even taking their view as true, they have clearly indicated that the Commonwealth is not investigating the death of John O'Keefe. That seems black and white, just a fact. So what we have here is either this is the DOT saying the federal investigation is preventing us from giving you these documents, or this is made up from scratch. It is completely fake. And I wanted to know which one it is. So DOT did not follow any of the statutory procedures in denying my request. They were supposed to, even if they're going to deny, they were supposed to do a lot more work than they did. They were supposed to say, here are all the categories of responsive documents. This is why you can't have this one. This is why you can't have that one, and go through each category and really explain. They did none of this. So I knew that I have a strong basis for filing a lawsuit. I knew that I would win, whether it's at the trial court level or on appeal. I am right. And I say this because I do data privacy and security litigation. I do a lot of complex areas of developing law where there, in many cases, there isn't law. Courts have not addressed the issues that I litigate. So in a lot of the lawsuits that I am involved in, I am used to making both sides make creative arguments for the development of law. This is sort of the polar opposite of that. It is so black and white what the law is that it is very crystal clear who is right and who is wrong. And in this case, I am right. And I don't think that there is a valid legal argument against it. And I don't know that I have ever said that before, that there is literally no legal argument, even a creative one, that the other side can make. There just isn't. So,
Yeah.
Go ahead.
I was gonna say, so you filed the lawsuit, and within a couple of days they gave you everything. And like, what did they give you? How did that tell us the rest? Because this is
Yeah.
interesting that they're and did you find out, is it the Fed? I'm asking like 10 questions at once because I'm interested, but like the federal part too, like that's fascinating. Did you find out, like, is it because of the federal, or were they just not following the law? Like, what's the deal? Tell us more about this.
So I filed the lawsuit on Monday. And on, I guess, Thursday evening, I got an email from the DOT records access officer with a link to what they have said were all of the documents that I had asked for, which is, that is insane to me. That they didn't try to fight it in court. I suspect that I don't know what their counsel thought, but I suspect someone looked at it and said, I'm not going into a courtroom to defend our position when it is completely invalid. But the fact that they gave up on this objection because of the open investigation related to the ongoing civil trial, they just gave up on it. That means it was not real in the first place. It is not because of a federal investigation. It's because they asserted a completely baseless exemption. And it's very simple. There is no other explanation for why it was not okay from March through last week, and it was perfectly fine starting on Thursday.
Do you think
the
DOT's been politicized? Like, why are they trying to hide this? The Department of Transportation should be nonpartisan, right? I mean, why are they hiding this?
I don't know, but if I had to guess based on my experience with DOT in other states, it is simply, I don't want to say laziness, but I don't necessarily think it is political. I don't have an opinion one way or the other, but just using context clues from dealing with DOT elsewhere, it seems like it was just I don't feel like it.
Yeah, this is always lazy. There's a lot of laziness. You can't discount laziness. That's so true. They don't want to do anything.
No. And lo and behold, they did it. And I will say one thing about a lot of these public records requests is that they require a lot of redactions for sort of personal information. And that can get really expensive. I think for most jurisdictions, there are 4 hours of, that they can't bill for, but if they have to review documents to redact more than 4 hours, then they can charge you, and the bills get really high really quickly. If you bring a lawsuit and the agency did not follow the statutory procedures, then the fees get waived. So they didn't give me a hard time at all about the redactions in the documents, and there are quite a few redactions. So I suspect that they sort of gave up on that. I think if there was no lawsuit, my guess, and I don't know for sure, I think they would have tried to send me a bill first.
The thing about our law too in Mass is that it applies to certain agencies, the towns and cities, but it doesn't apply to the governor or legislature. The Mass auditor just made a statement that she may be doing a ballot initiative to make the governor and the legislature follow FOIA laws for themselves. Does that make sense? Is that what you see in other states?
I don't know. I've dealt with public records requests in other states, but I have not received pushback from whatever I've requested in other states. So I guess I haven't experienced this before. And I say that with this Massachusetts law that I think is the broadest of all of the laws in any other state in which I've submitted requests for various reasons, which is kind of odd that it's the best law, but the worst application of it by the agencies. So I don't know the details of who it applies to in terms of the governor, et cetera, but I think it would be consistent with the alleged goal of the statute to broaden it and make it apply to all government entities.
Totally. I would like to see that, especially the Massachusetts State House. There's like so much lack of transparency up there. Um, so now you file the lawsuit. Did you actually have to go in? You must have had to. Did you fly up here for this? Like, because you're out of state. Like, how did you negotiate filing a lawsuit against them, and how did that go?
Yeah, so I filed this lawsuit pro se, meaning I'm representing myself. I'm an attorney. I pro hoc in other states besides the state in which I am barred all the time. But you have to have an in-state attorney to sponsor you, as we saw, obviously, David Yannetti and Victoria George sort of sponsored pro hoc applications for Eliza Little and Alan Jackson. So I would need someone in-state to do that. But in that case, I couldn't argue the motions myself. I couldn't appear in court and litigate. I am represented by, or rather, if I were to retain Massachusetts counsel, I couldn't do that. I could, I suppose, pro hoc in. No, I don't think I could because I'd be representing myself. It became sort of a weird quagmire of sort of the procedure, and I didn't want to get hung up on procedure. I was also being really impatient because I knew that this would take a while as well, and I just thought I'm just going to go for it and do it myself. And as a result, I am not acting as an attorney in Massachusetts. I'm not barred in Massachusetts, and I'm representing myself without pro hoc. So I wasn't seeking attorney's fees unless for some reason I got an attorney to help me down the line. You know, I want to reserve the right to have them be able to recover their fees. But I'm not seeking attorney's fees, which I think should be persuasive to a court as well, that I'm not here to make any money, and in fact have spent plenty of money to get this lawsuit filed and going in the first place. The point is to get the documents and to make the agencies follow the law. That is the whole point. I am not trying to make any money. It's a labor of love or labor of spite, however you want to look at it. I'm a lawyer. It's all about framing. Either way, give me the documents and follow the law. That is really all I wanted. But I think that
Oh, go ahead.
your original question was, what kind of documents did you get? So I got a very, I do not think that I got all of the documents that I requested, but I am still sort of working with DOT to try to make sure that they have plumbed the depths of all of their sources of documents to get all the documents that I asked for. So what I got was the vast majority of it was Trooper Paul's report, or two reports really. And then some of these specific documents that I requested with the emails attached, I haven't put those out there far and wide because I'm trying to use them to negotiate some additional documents. But I will as soon as I can. I just want to make sure that I have covered all of my bases and sort of put myself in a position where I can get everything that is public record and responsive to what I asked for.
So what did you say you received it, but that haven't put out yet?
Right. Just a handful of documents. It was really only about 15 pages of additional documents besides Trooper Paul. I've sent them to a few people to look at. And so I am really just waiting to get feedback from those folks to make sure that we are approaching this in the right way.
Is there anything juicy? Anything that like you can give us a hint on even without giving it away? Or
yeah, it's and I'm really not trying to hide anything. It's more about just making sure that I've covered our bases and can negotiate with DOT to the extent necessary. But there is a fatal accident notification report. There is an immediate threat report, and there are some communications back and forth just internally at DOT. One email from Michael Proctor saying that he did, well, one email asking him to fill out the fatal accident notification report, which he did several days later, which no surprise. It's surprising that he did it, I suppose, but he got around to it eventually.
Wow. So that, I mean, it's pretty awesome that you eventually got these documents and it only took a couple days after you filed the lawsuit. But it just goes to show you how, like, because I file these FOIA requests a lot in the past too, and it got blown off. Sometimes I'd get them, sometimes I wouldn't. And, you know, you can appeal. I didn't even bother appealing most of the time. I know some people do, but it's you definitely in the end have to try to sue in a way a lot of times to get these kind of documents. That's kind of where then they start following the law when people start suing, unfortunately. That's a sad truth, isn't it?
It is, and you know, I agree with you on the appeals. It seems like I mean the appeals are all public. You can look at them on the Secretary's website, and I've looked at plenty of them for all different agencies to see what they do. It doesn't seem like the supervisor requires production of documents very often. What the supervisor does do is requires the agency to go back and do all the procedural things they were supposed to do, like identify the categories of documents that exist, why they're being withheld, or what other agency might have them in its place, you know, those procedural things. And the SJC in Massachusetts has said that the appropriate way for an agency to handle this is through providing a document log. The SJC is, I mean, that is a lot of work to create a document log, but the SJC said that is how this should be handled. So there is a basis for asking for a document log, and the agencies just don't seem to do it well. I won't say the agencies across the board. The ones I have dealt with thus far have not actually provided this log. But what the supervisor does in a lot of these cases is says, go back, agency, and put together and fulfill your procedural obligations. So that is a reason to appeal, is that the supervisor does ask these agencies to do the work that they didn't do. Why I was displeased when I got my supervisor appeal is that the supervisor did not make the agency go back and do that in this case when they so obviously had not done any of their procedural steps that they should have done. The agency essentially just gave a one paragraph, like, there's a lawsuit that's going on, a civil lawsuit, therefore my hands are tied. Well, I'm choosing my cuss words carefully, or filtering them out rather. It's just nonsense. That's just not how it works. And the statute is really clear that that's not how it works.
Now, people in the chat are asking for different things for you to FOIA. Were there any videos? Did they provide any videos by chance?
No videos, but the video John gave Kevin Albert, I think I know what that is in reference to. I imagine that would be, if it was given to Kevin Albert in any sort of professional capacity, then that should be in the Canton Police Department's possession. I know that folks have not had great success getting documents from CPD in the last few years, but with the recent regime change, maybe things are different.
People want to know if the reports were dated around the time of the accident. Who knows? It could have been 2 years later, the way they operate.
That is a great question. They were dated the same week.
They were. Okay. We also had another question about, was there an accident report? Did you see any accident report from DOT?
Not besides the fatal accident notice report, which is really just like the, you know, fill in the blank, like 5 blanks, address, date, name, location of incident, that kind of thing. There was no real report, crash report to go with it at all. And I will say this. So my initial request was for emails over a 3-year period. And the agency came up with some search terms to search for all these documents and said they had hundreds of thousands of responsive emails. Then then they email me and said, here are all of the documents responsive to your requests. And it's like 6 emails. Do you see why I do not feel like
doesn't add up?
Something does not add up.
Yeah, I can see why you think there's more documents out there. Definitely.
1 or 2, perhaps. So I haven't dismissed the lawsuit by any means. I need to run this to ground.
So it sounds like it may continue. It may continue to get more because you want them all. You want them all.
I want them all, and I'm entitled, and I didn't get a response in the 10-day statutory period, which means all fees for redactions should be waived. I believe the statute says they shall be waived, which means mandatory, without exception. I want them, and I don't want to pay for them.
Definitely. And there's also some questions tonight about because you're a civil attorney. Bonnie had a question about the civil, because there's a civil lawsuit that was mentioned. You mentioned earlier against Karen Read and the insurance companies for the restaurant bars. Bonnie says, Mike, if there's no crash death reports in civil lawsuit, how would Karen Read Auto Insurance settle? What do you think about the lawsuit in general? Do you think that lawsuit's good, or do you think it's like is it a waste of time? Like, how do
I
you
mean,
look? I mean, do you know anything about it even?
I know about it. Certainly, I've read some of the documents related to it. I don't do personal injury type litigation, but I can say it's not entirely baseless by any means. There is some there simply because of the fact that there are allegations and there is some evidence of an incident that night. There's taillight that is smashed. The criminal case resolving in Karen's favor does not negate the ability for the family to bring this lawsuit in the civil case. I don't think it has merit, but I think that it is going to get past the motion to dismiss stage and will proceed most likely to settlement. I know folks say don't settle, etc. If Karen's insurance is involved, and I have no idea one way or the other about that, then they can certainly settle. It's just settlement values. It's the value of litigation and paying the attorneys. It is worth it to settle for some amount that is less than paying attorneys all the way through trial than it is to go through the business interruption and the trouble, essentially, and risk of losing to some degree. It's better to just settle early. I hope that is what happens, just to make it go away. For Karen's sake, she has far more important things to be worried about going forward. And even if she didn't have anything important to worry about going forward, she has been through enough for the last 3+ years. She should be able to litigate on her own terms, let's say.
Yeah, lawsuits suck. To get sued, just such a waste and drag. I gotta say,
I
going
mean,
through it myself. I'm going through it myself. It just sucks. So even
I know.
mine's really stupid. It's like I think I'm gonna hopefully win that.
Do you have an
Let's-
update for us on that? I don't know the status. Is it are you just waiting on the motion to dismiss stage?
yeah, yeah. We basically have written it. We waited for their prosecution response, and now we file our response. I haven't seen the response. It was due on Friday, so yeah, it's moving forward. The motion to dismiss is moving forward. We'll see what happens with it. Not about me tonight though, because I don't want to talk too much about it until I can. You
Fair.
know, when I'm ready to. I was hoping I'd talk about it like in the last couple of weeks, but I'm just doing what my lawyer tells me for now. Like I thought we'd
Smart.
be able to share it as soon as it came out, but it's like we're still waiting. Um, so yeah, let's talk because this civil lawsuit against Karen Read, I always think like when the family is suing Karen Read in these restaurants, I think it's very surprising, but not surprising. But I think it's wild that they're not suing the homeowners. Because if the homeowners hadn't invited people that were allegedly drunk back to their home after last call, if they hadn't invited people over, John would still be alive. To me, they would be easy lawsuit to file a lawsuit against them, the homeowners. Am I wrong? Do you think it's surprising that they didn't file a lawsuit against the actual homeowners?
I don't think it's surprising for many reasons. One, practically speaking, those homeowners are going to be witnesses that the plaintiffs likely think are favorable to their case, and you may make a business decision, let's say, not to put yourself at odds with witnesses who you think will help your case. I also think that the theory of liability that they're pursuing is would make the homeowner's liability fairly attenuated, and saying if it's just based on the fact that they invited some folks over, that is probably not going to get you there in terms of a lucrative settlement, to say the least. I don't think that would get past the motion to dismiss.
So not only is it beneficial for them not to because of the witnesses, but I'm kind of wrong on that it wouldn't be a good lawsuit. That's interesting. I guess I'm thinking like always the host law, but that's really for underage people, I guess. I guess if Karen had been underage, then it would have been a lot worse for the homeowners, I guess.
Definitely a different story.
Yeah, that makes sense. I'm glad you talked us through that. So, there's a lot going on right now. There was some other documentation dropped this week from NBC and from Jessica Machado. Have you seen some of the other emails that have been coming out from Michael Morrissey this week?
I've seen some of those emails for sure. I was trying to think earlier about like which email do I think is the most interesting, because there are so many interesting ones in there. I will say from my perspective, having gone down the public records request route, the one that I found to possibly be the most interesting in that regard is the email from Morrissey saying that he's paying for aperture out of forfeiture, which is just it is exactly what I thought was going to happen, but I'm feeling vindicated, feeling proven right to some degree, because I've been pursuing the Norfolk County DA's office forfeiture trust fund invoices for quite some time as well, and I think that's how Morrissey would have used funds in this case, because they aren't appearing in the budget line items for Massachusetts.
Yeah, I thought that was very interesting, as well as asking the Speaker of the House for an extra $1 million, right? I mean, that was another one that was just, I couldn't believe that one. You just right. Give us $1 million. We need $1 million to go after Karen Read for the most expensive OUI conviction ever.
That was wild. And I will say that letter, I believe, to the Speaker I believe that was sent on October 2nd. And the email about having to pay for aperture out of forfeiture was on October 3rd, the next day. So I'm wondering, did the Speaker say
No.
absolutely not immediately, or did he just, how did that come about?
Because I know, right? Was it a backup plan? You just like, we'll use this until we get the money from the State House. So yeah, it's I wonder how that went down.
Yeah,
I wonder
maybe
if he got the $1 million.
That's right. I don't know. So I thought that sort of series of emails related to Aperture was super interesting. Plus the line item invoices from Aperture generally. One of the most interesting observations that I did not make, but of looking at the Aperture invoice, was the fact that Aperture purchased, it looks like, a bunch of taillights. And I don't recall them having done any test that they showed the jury, at least, with a bunch of taillights. Do you?
Right. No. Do you think they did them and didn't show them because they were so bad?
One could draw that conclusion.
Well, maybe they just wanted to bill for some extra money. I wonder if they can return those taillights if they don't use them.
Well, they did leave the Judd Wilcher, I believe, left the tag on the hat, didn't he? Think he returned that?
Yeah, I wonder.
Do you think he returned it and billed back to Norfolk Couney? I would love
Maybe.
to know.
I mean, I wouldn't put anything past that crew after what I saw. The
I know.
The Blue Man Group. I mean, come on. Yeah.
Speaking of, should we look at Trooper Paul's report then?
Yes. Is that still in the document we had up there?
It's not in the complaint, but the other document I loaded, I just did a, like 10 slides on some highlights I thought were interesting from the report.
We can add it. I may have to remove the other one. Are we done with the other document we were looking at?
I think we're done with it, but I've got the Trooper Paul up there.
Oh, actually, you got the other one. It's we don't have to remove it. We can keep them both there. Cool.
Okay.
There it is. I think. No. Is that still?
There we go.
There we go.
Okay. This is the first page of Trooper Paul's report. Seems fairly professional. I put some red boxes around these key points that I thought were super interesting. The first of which, the top red box, says the requesting agency, which I take to mean requesting the report, MSP detectives, as we know. Date received, meaning the date Trooper Paul received the request for this reconstruction, was January 29th at 2:30 p.m. Now, I went back and looked at Sergeant Barros's report. He got a call from Trooper Proctor at 3 p.m., 30 minutes after Trooper Paul was asked to reconstruct the accident. So Proctor hadn't even gotten to Karen's parents' house. He hadn't seen the SUV. He hadn't spoken to Karen. He had spoken to Jen McCabe, Brian Albert, and a couple of the first responders. And that is from this, I take that was all that he needed to bring in Trooper Paul to do a full crash reconstruction report at 2:30 p.m. on the 29th. Isn't that wild?
That to me, looks like fraud. Like, I'm sorry, that does not look correct. That looks like they just backdated it. That's just my opinion.
You're certainly entitled to it. Related to that, on the first page is the collision occurred. The second box down. Collision occurred Saturday, January 29th at 12:15 a.m. That's a mighty specific time.
Yeah.
Where did that come from? I don't know. If we go to the next slide, I think I can go. Okay, next slide. This is page 2 of the report. Note, this report page also says 12:15 a.m. is the time of the collision, which keep that in mind as you look through the report. Okay, this I thought was fairly interesting. There's a date on the bottom of the second page, October 22nd, 2024, which seems like the date of the report. That is obviously several months after the first trial. Now, I saw last night Turtle on his show showed Trooper Paul's report, and it was dated at the bottom in the same sort of format. It was dated May 2023. So that is obviously different from October 2024. I, in practice, have never seen an expert report get changed or amended or anything like that that wasn't called the amended so-and-so report.
Right.
Ever. You rename the report to ensure that whoever is looking at it knows that the report said one thing to begin with and changed afterwards. So, for example, if this went to the jury, and I believe that this Trooper Paul report never made it to the jury, neither one did, but if it had, and if it wasn't elicited at trial otherwise, the jury would never know that there was a prior version of the report. That is wild to me. I've never seen that ever. And I've seen plenty of amended or corrected expert reports. It's just intellectually dishonest, in my opinion. Okay, so obviously Trooper Paul amended his report somehow after the first trial because he did have a pretrial 1 report, and this is post-trial 1. Then I started looking at the details, and this is just like an example of one of the many ridiculous parts about his report that I just pulled out. So on the left-hand side, underlined in red, it says, the lighting conditions, dark lighted roadway. The weather conditions, snow. The road surface, snow. At the very end, in his conclusion section, he says, there were no environmental factors or roadway defects that may have contributed to this collision. How is that possible? If dark lighting conditions, snow coming down, and snow on the roadway is not an environmental factor that could impact a car accident, what is? A tornado?
How would he know too?
How would
how would he know that it didn't happen? You know what I mean? Like there's no. Yeah, that's stretching. That's definitely not on point.
It's absurd. He even records these facts: dark snow, and the conclusion he draws from it is the opposite of what even a normal person would draw, much less an expert. It just defies common sense. It's counterintuitive. it's absurd. I was thinking as I'm reading through this, the defense's head must have been spinning off as they're going through this report, because they have to choose
Where are you gonna go?
which one of the 9 million, or which 2 or 3 of them are we going to focus on in front of the jury? Because almost every single paragraph in this report has something egregiously intellectually wrong with it.
So yeah, this is like they call it flooding the zone.
If you, yes.
That's what they were doing a lot here. They'd flood it with so much BS that I felt like this was the defense's issue. Like the first trial is like they tried to deal with every piece of BS, and you can't. You just got to focus on a little bit because the average brain can't handle too much BS, right? Is that?
Yeah, and you have to, the jury can only handle so much complexity. You have to boil it down to what matters to them, and you have to make some strategic choices based on experience and based on your experience as to what is the jury going to care about? What are they going to take our sort of view on? You cannot go through all of these, because then it becomes a throw spaghetti at the wall and the jury takes from it absolutely nothing. So here's another paragraph, a couple of paragraphs that are silly for many reasons. The first underlined red line says that, the investigation reveals that on Saturday, January 29th at approximately 12:45 a.m., Alexis, blah, blah, blah. So the first 2 pages of the report say this happened at 12:15. The conclusion and the analysis say it happened at 12:45. I mean, that's a huge difference.
It's a half hour. That's a half hour difference.
Half
That's
hour
a lot.
difference.
That's a lot of
And
difference.
the citation that Trooper Proctor allegedly put together, well, he didn't actually put it together. He signed it, but we'll get to that later. That is dated and timed at 12:33.
How the hell did they? Don't they proofread? Like, it's unbelievable that he'd have in the same report. It'd be one thing if it was like different reports and you maybe forgot, but it's your same report. It's like,
Yeah. So then at paragraph 47, Trooper Paul says, post impact with the Lexus, he, meaning Officer O'Keefe, was projected forward and towards the right for approximately 12 feet. That is incredibly precise, even for a technical expert. A range would be reasonable, 10 to 15 feet. But Trooper Paul says 12, incredibly specific. There is no calculation to go with that 12 feet. Where did that 12 feet come from? You will read his report cover to cover, and there is no answer. This is why Jackson's head is spinning off in trial 1 when he is trying to get Trooper Paul to explain how he arrived at any sort of analysis related to how far John O'Keefe was projected, allegedly. Assuming that a collision happened. It didn't, but this absurdity, must play out. During the questioning, Trooper Paul agrees that it is likely that the Officer O'Keefe was projected 30 feet. Well, where does that come from? That is more than twice the distance that he estimated in his report, which also has no analysis to go with it. There's a reason why experts have to provide a methodology, and it is so that the attorney on the other side can look at that methodology and show to the jury why or why not the methodology was done appropriately. Here, it looks like Trooper Paul plucked a number from thin air, which is most likely what happened, and just put it in there. And then he got to trial, and the 12 feet didn't make any sense. So he says 30, and there's nothing to support either one.
Unbelievable. Like you said, too, if it was a real number, it would have been a plus or minus. It would have been 10 feet plus or minus 5, or plus or minus 2, or there'd be something. There'd be some kind of range, right?
Something, or more importantly, a calculation to go with it. How I got there. That is what the expert is for. That's why they are paid. How much their experts are paid a lot of money, and it's for a reason. Maybe not Trooper Paul, but generally speaking, they are doing very complex work and calculations when it comes to technical experts. And there is nothing in this report. I cannot believe how little there is. Even for Trooper Paul, I've watched his testimony multiple times. It's absurd.
Like I wrote it. Like I came up with it. I think I have no idea. Just making up numbers. Just make up some numbers here.
Maybe you at least know to capitalize, proper nouns and whatnot
Oh, I got
mean.
spell check.
Basic. So here, this is another one that drove me nuts because it's just, again, Trooper Paul just concludes things that should take up, each sentence here should be a page or 2 pages in a normal expert report of explanation. He says SPDU, which is MSP. So MSP noted the Lexus's path of travel after leaving 34 Fairview. These locations were given to me and I used Google to map out each direction. I read these 2 sentences and I want to scream. This should take several pages and citations to authority, to reports, to the factual basis for all of these statements. And there is nothing. He threw in like 2 footnotes in the entire report. Almost every sentence should have a footnote with authority for where this information came from. MSP noted the Lexus's path of travel. What did they note? They noted it. What was it? He doesn't say. Where did they note it? Where did it come from? Did it come from Allie McCabe? Because if it did, then you go to the report on Allie McCabe and see if you as the defense attorney can discredit it. Or Matt McCabe, or was everyone consistent? You have to say where you got it so the other side can determine whether that was a proper source for that information, and if not, has the right to impeach that source in front of the jury. But here, they didn't provide any information. Now, I think that the defense made a very smart and, for me, very entertaining choice not to challenge Trooper Paul's this report in pretrial. They wanted him on the stand, I believe, to destroy him in front of the jury, which is what I saw in probably the most incredible cross-examination of a technical expert I've ever seen in my life by far. It was wild. That is the sort of incredibly intelligent, experienced, skilled type of decision-making that the attorneys made in pretrial to be able to succeed at trial. And they annihilated him. This report should have never come in. There is no methodology. There are no underlying facts based on the report. He just says things. And that's it.
No notes, no notations, know where it came from.
No.
Just trust me. Just trust me, bro. I'm
Just
Trooper
trust-
Paul.
Exactly. And then the second sentence, these locations were given to me and I used Google to map them out. Okay, as an example, like 2 weeks ago, I submitted a motion to transfer the venue from one case from one location to another. And I'm bringing in facts from outside of the courtroom, from outside of the docket. So I signed an affidavit under penalty of perjury because I'm providing new facts to the court. And I was just telling the court the distance between 2 locations. This is so basic. And I use Google Maps. I am not an expert. I was simply providing like 2 distances to the court, but I provided an affidavit. I said I input specific information and addresses into the Google Maps directions function. And I did it using, this method, the car driving distance or whatever it was I said, and just basic details about what I did. And then I attached the screen captures of the 2 distances that I ran for the court as exhibits to my sworn affidavit. And that was just to tell the court something that the court could obviously look up on its own if it wanted to, but I'm providing outside facts in the proper way. And that is just as an attorney, not an expert. Trooper Paul should have done something similar, if not far more robust than that. But what does Trooper Paul do? He says, I use Google to map out each direction. What are the directions? Did you use Google Maps? I know in the next sentence he says based on Google's maps, suggested directions. But that is just one example of how Bush League this sort of report is, and just at the most basic level omits basic information. And then I watched, I listened to his testimony again, and he actually provided even less information on the stand, which was alarming. He said, I put it in the sink. And that was it. I put it in the thing. I'm like, I put it in the thing is just put it in the thing is what I say to my friend when we're going somewhere. And I'm like, oh my, they ask me, how do we get there? I'm like, just put it in the thing. Just do it. Not testifying as an expert in a murder trial on the stand. Absurd. I know we all know that Trooper Paul is absurd. And it kind of is not even worth talking about to some degree. But going through this report, I'm just like, oh my God. The fact that Alan Jackson kept it together as much as he did is even more impressive now, having read this.
Just like going back, I'm like, we got to play some Trooper Paul at the end of the show tonight. I'm
Yeah.
jonesing for it.
It's worth it. It's absolutely worth it. So one thing we did learn from these documents, and by the way, I don't know why MassDOT had Trooper Paul's report. I suppose it is a crash report. They didn't have the prior version. They didn't provide it to me. They didn't have the 2023 version, but they had this one. It wasn't attached to anything. It was just sort of standalone. I'm not quite sure what to make of that. But nevertheless, here we have Trooper Paul saying that he conducted his testing on July 24th, 2024. That's a little over 3 weeks after the first trial, right? Now, throughout his report, he says when he did a lot of these things. On this date, I did this, blah, blah, blah. Something he does not have a date for is when the Norfolk County District Attorney's Office requested his assistance in conducting the second round of testing. He just says it without a date. Now, as we know, Adam Lally, obviously, I can't remember which prosecutor actually initially discussed this with Trooper Paul, but when Trooper Paul was on the stand, Adam Lally tried to elicit an opinion from Trooper Paul about Karen backing up her car into John's Traverse in the driveway. Remember that? Alan, raised a ruckus. They had a motions hearing outside of the presence of the jury, and Judge Cannoni thankfully said that this opinion could not come in because it hadn't been to disclose to the defense in advance, which is like 101. And this report proves that even more, because this is like a 15-page report on his opinions about Karen backing up her car in the driveway. A 15-page report that and the prosecutors were trying to boil down to just a couple sentences opinion to slip into the jury at the end of his direct examination in the first trial, knowing that this really was worthy of a multi-page report disclosed to the defense with testing in advance. It's so offensive looking at this and then going back and seeing what they did to try to get an information that was totally inappropriate and not disclosed to the defense in advance. And then Adam Lally, I remember this very clearly, said that it was laughable, the defense's objection to it. Do you remember that from that hearing? Even Judge Bev was offended. Yeah. It's like the only time she ever got mad at Lally was when he said it was laughable that the defense was objecting to it. And it was this absurdity that they now realize after the trial they needed to do a full report and workup on. So this is the backup. Karen in the driveway backing up. Okay, there's just one point that I thought was worth noting from his report. So what he does is a whole bunch of different sort of versions, iterations of the Lexus SUV backing up into the Traverse. And his whole point is that it couldn't have cracked the taillight. Well, I would submit that there are a number of technical deficiencies with his analysis, but that's like besides the point. It's kind of irrelevant. But he does these are the three pictures on the left are from his report. And he does these sort of different setups and says it couldn't have happened this way, it couldn't have happened that way, blah, blah, blah. Okay, the top and bottom sort of testing, the way he lined up the cars. Why did he do it this way? We have the picture in the video of the way in which the Lexus backed up and made contact with the car. And he has selected to do testing on sort of iterations of this that did not happen based on the video. You would have to turn the car 90 or 180 degrees to come up with this sort of mock-up. And he spends 2 pages on the top scenario that never could have happened, one page and really want a couple of sentences on the middle paragraph, the middle picture, which is what happened. And then like 4 or 5 pages on the bottom one, which also could not have happened. So the vast majority of his supplemental report is testing scenarios that, according to video evidence that we have all seen many times, could not have happened. I don't even really know what to make of that. I found it so absurd. He's taken all these pictures of the car lined up in positions that it was never in, obviously was never in, and says, look, that didn't happen. Yeah, we know it didn't happen. We have the video. It's so stupid.
It's crazy.
I mean, that is a more offensive waste of money than almost anything. Yeah. He did all these fake tests for scenarios that absolutely didn't happen unequivocally.
Yeah. And we saw, like you said, we saw the video. Dude.
Yes. I don't even know what to say about it.
It's just like, it's so silly. It's like, what are you doing?
What are you doing? I don't know. So that's what he did. And then the other, obviously, gem that we got from this supplemental report that he provided is this
the arm.
The arm. What do we do with this? I mean,
Yuri. He's got, look at the glass he's got. Oh, man.
It's like a big gulp. It looks to me like, you can't really see in this picture, like the plastic cups that they have in like maybe like the lunchroom or like K&W cafeteria.
Yeah, it looks like one of those plastic tumbler glasses. Yeah, definitely. The ones you give the kids, you don't want them to break the glass.
That's the one that they choose for this experiment, test, whatever it is. And then you go to the next picture. I mean, look how far his body is from the car. He's left, a foot for Jesus between him and the SUV here. But the picture where he's actually lining it up, he is going to get steamrolled by this vehicle. Just on these 3 pictures alone, the scenario is impossible.
I know, right? Even if you started like that and you moved your legs, why wouldn't you move your arm? Like you can move your legs, you're moving your arm. It's
the number of things wrong with this is absurd. And they took these 3 pictures, which each one obviously could not be what happened for many reasons. They took them and then they bring in Aperture. Then they hired them to recreate this for $400,000. That is absolutely insane.
Biggest waste of money ever.
I don't know what to make of it. This happened on July 24th, according to Trooper Paul's report, which I believe was around the time that Michael Morrissey was identifying Aperture. So Aperture could not have come up with this because these pictures happened the day of, or the day after. I believe Morrissey said, "Hey, maybe we should hire Aperture.
Maybe we need somebody more than Trooper Paul."
Yeah. So here we are. So I never thought that asking MassDOT for, the crash reports would actually result in the Trooper Paul's second version of his original and supplemental reports. And I definitely did not think that Yuri Buchanan would be the lead actor in these alleged reenactments. But here we are.
Isn't it amazing? You did actually get something new that none of us knew about. None of us knew about any of this, that they did this before Aperture did the same thing with blue paint, actually. I guess that's what the money comes in. They needed to buy blue paint.
Well, it was grease paint, so I'm sure that's very expensive.
Yeah. And I'm very happy I did find the Trooper Paul video. I think we're going to play that at the end of the show.
Do it, yes.
Flashbacks tonight.
Yes, I like that. It's a great idea.
It is.
So that's all I got. That's I hope to be sharing the citations and all that other paperwork very soon. And I do hope that I get some documents in response to, I talked about the forfeiture trust fund. The Norfolk County informed me last week that they would need a few more weeks to fulfill that request. But I've got a few cooking with some other agencies that I think might be just as productive, or hopefully more so. So I hope that I don't have to take any future legal action, because it is a huge pain in the rear and it's expensive. I mean, it's $300 to file a lawsuit. plus other sorts of expenses, not to mention all of the time that I am not spending doing actual billable work on my cases. But it is also one of the very, very few ways in which you, as a citizen unrelated to the case, can potentially create change. I would encourage anyone who can submit a public records request properly to do so in a thoughtful way. But it's very easy to at least do and sort of get the ball rolling.
Excellent. I heard from somebody today in the community who was asking me for. I've talked about Muckrock. Muckrock.com is a way that people, if they haven't done a FOIA request, you can do it through this website. It does cost a little money. You don't need to do it that way, but someone requested that from me just today because they're doing FOIA requests now. It seems like it's catching on after the last few days of all the disclosures. So I think you're helping people think about what they could be asking for, Corey.
Yeah, well, the more the merrier when it comes to people thinking about this stuff, because as we've seen, people, pull a fact from one document that was produced in this Morrissey document dump, and someone else has another fact, and you join them together, and you start to see real connections. And when you put together all of the people involved and the timeline of events, you start to get a really clear picture of the way things have gone down throughout these multiple prosecutions, or persecutions, probably more accurately. And it's alarming. So I'm really glad that folks are taking steps in the same direction, because it's going to require a lot of people to put in time to sort of plumb the depths of this.
Now, I know that in the past you were a little cautious about using your name and your law firm. You are like, you do have a real job, like it's serious, like a serious firm. You're a serious person. This is kind of a big step for you. Are you worried about it? Like, has there been any trolls coming after you yet, or people just kind of calming down with that shit?
Not in the last 48 hours. There's plenty of trolls on Twitter, but I mean, that's just what Twitter is. It's sort of silly. I'm really not. I don't think I'm doing anything offensive besides trying to get the government to follow the law. I want everyone to follow the law. People, individuals, government, just follow the law. It's not that hard. And I think the public record statute is very straightforward and easy, and it's easy to follow it if you just read it a couple of times. Tells you exactly what you need to do. I mean, there will be trolls and there will be offensive people, and I do not care about them at all. So I guess that is how I feel about it.
Good. I'm glad, because you do a great public service there with your Twitter account. We have it pinned in the chat. I hope people follow Corey on Twitter. Make sure you're following her if you haven't already. I know a lot of people are, but make sure you hit that follow button at the top of the chat. It's pinned at the top of the chat right now. I want to ask about Aiden Carney, because Turtle Boy's coming up on court this week. I'm assuming you're following that as well.
Oh yeah.
What do you think? What do you think about what's going on with Aiden and Turtle Boy and Norfolk County? Do you think any of these drops from Michael Morrissey, the emails and messages he's been sending out, does that help Aiden, you think?
Oh, I'm glad you mentioned that. One of the emails from this Morrissey dump, in which I believe Morrissey was sending the witness intimidation statutes and other statutes to the Massachusetts AG, if I recall correctly from
Yes.
Turboy's description, in the 2 weeks before the rolling rally. That is horrifying to me. Truly horrifying. If you, as the district attorney, are concerned, truly concerned, that a citizen of the Commonwealth is about to have a crime committed against them, and we'll just play Morrissey's, theory out and say that it was a crime, which I don't think it was at all, to say the least. Say, if you are really concerned about that, in advance, you do something about it to stop it from happening, whether warning the individuals or something. What you don't do is send emails to other law enforcement agencies and say, I can't wait. Essentially, what you are saying is, let's think of different ways we can get him when he does this thing in 2 weeks. That like blew my mind that exists. And I'm sure there's plenty more in that regard. I mean, we've seen similar sort of advanced conduct by Tully and others. But for the DA to do that, I wanted to throw up and cry at the same time. It's so disgusting.
Yeah. So you notice too, in those drops, what we don't see is the AG's response. We don't know what she said back. Uh, I'm dying to find out. I hope we can kind of maybe file some suits and get that response because what did she say back to him? I want to know what she pushed back because I have a feeling she wasn't receptive to it. Doesn't seem like it.
If I had to guess, and I don't know, obviously, first of all, I believe the request related to emails to and from that account. So in theory, it should have included emails received by that account. I suspect that the AG, like most other agencies or public officials, particularly at that level, know enough not to respond to something so stupid and irresponsible that is going to be subject to a public records request. You don't respond in writing.
Right.
You call them, if anything, or more likely what happened, hard ignore, because it's an absurd thing to do. And I suspect that someone reading that also knew that sending an email suggesting that you're gonna, catch someone in something that they are planning to do in the future is unethical.
Well, it's like pre-crime too. Like that whole thing where he could have just. I think too, if you had told Aiden, like this is going to be witness harassment if you do it this way, I think he would have heard him. I don't think Aiden even realized that they were going to go this way. Like, I
That
can't speak for him, but I think, you know, I agree. It's ridiculous that he sat there and watched it and sent them email like,
didn't try to stop it, didn't try to advise either side about how this conduct may be seen as a crime, just let it happen and then took action. It's so gross. I can't, I'm really shocked that it exists in writing. I mean, so stupid.
do you think it's going to help Aiden? Do you think that will help? Do you think the attorneys can use that?
I think there are defenses available, and if the defenses that could incorporate that sort of conduct, and if the attorneys sort of assessing the comprehensive scope of the evidence think that their defense is worth pursuing, I think they will. I would think that it is helpful, atmospheric, if nothing else.
There's also a message he sent to the Stoughton District Court about a woman named Michelle that often watches our show. Actually, she may be here tonight watching. Um, I think his messages were out of line on that one. Like, could he have some liability on what he did to her? Because I feel like his messages in writing about this woman, I don't know. I don't know. I'd be worried if I were him. It doesn't seem like it was too HR compliant. Let's put it that way. Could he be facing some issues from her, possibly?
I don't know how the 1983 analysis shakes out, or if I don't know what happened with her exact situation, if she was terminated, if there's some sort of wrongful termination avenue. Liability for prosecutors is probably the hardest category of government misconduct to prove, just about, in terms of at the prosecution level. So I don't know about that, but it is so inappropriate for a member of the prosecutor's office to contact a judge about an open matter. That is mind blowing. That is what is mind blowing. And the fact that it came from not his official email takes it to the next level of disturbing. It's just so inappropriate. And I saw from the Inspector General that they had done an analysis of the Norfolk County DA's office's cybersecurity issues, or deficiencies rather, from 2023, I believe, is when the audit was conducted, in which they found violations. They found, I believe the conclusion was essentially, you guys aren't actually training anyone on anything related to cybersecurity. Well, that much is clear based on all of these emails, because they have to
Yeah.
violate. I mean, it's a safety issue. It is safety of the government for 9 million different reasons, and for the people as a result.
Yeah,
And the fact that there was an audit, and he has still done this, and I think through 2024 there are emails. The audit was done in 2023 and published in 2023. That should have been the end of it, but it wasn't.
they also have like the worst clearance rate on murders in Massachusetts, Norfolk County. So they got a lot of issues. There was another one I'm glad came out from Kate about the colonel emails. Did you see he was sending messages to the colonel of the Mass State Police? The question: are DAs allowed to talk with the state police colonel about an ongoing investigation and trial like Morrissey did? Could that be an issue?
As far as I know, the MSP would be part of the prosecution team. I don't know of any sort of legal basis for that being inappropriate. I was, though, really interested. I think one of the emails, at least from Morrissey to Colonel Mon, related to Aperture, or no, maybe it was Ian Whiffen, one of the experts in the Karen Read prosecution, talking about how the expert could be beneficial to both of our positions, something along those lines. I'm paraphrasing. Obviously, we know what the prosecution's position was, but I would really like to know what the MSP position was that Morrissey was referring to. Because in theory, if they are on the same prosecution team and they're just talking about a particular investigation and prosecution, they should have the same position. But that email suggested they had different positions and that the Whiffen report would be helpful to both. I found that very odd, and I don't know what it relates to.
To me, the emails, I just wonder if they don't point to like get the defense to really want to put Morrissey on the stand, because I feel like he has kind of shown a bias against Aiden Carney with his emails, and especially the ones where he's talking to journalists, he's touting the journalist stories to the other state police. It seems like he's got a bias. Is there any kind of angle where they get Michael Morrissey on the stand because of these emails?
Bias or like sleeping with the enemy level obsession. It is out of
Yes,
control. It is
exactly.
a
Yeah.
true obsession. It's
Yeah, he's like KP. He's like obsessed like KP. Like,
I don't know what to say, but I will say that the hearing in which Rosemary Scapicchio got to examine Adam Lally was like definitely my favorite hour of testimony that I've probably
so
ever
good.
listened to. It's just what needed to happen. So obviously that got cut short. I hope it will resume at some point. I don't have.
Tuesday. It might happen again on Tuesday with Proctor and Lally. It might be this Tuesday, I think. So
Well, that would be incredible. There's nothing I would rather watch than that. But so I suppose there's a scenario in which Morrissey possibly could end up on the stand at some point. I think the legal battle to make that happen is going to be much uglier and more drawn out than what has happened with Lally and Proctor. But God, I loved that hearing so much. That's just what needed to happen. It needs to happen in every case. I want to say something else though about that is I know that they're going to the prejudice analysis with respect to Miles King in that case, and the judge sort of cut off the Lally examination because he said, okay, we need to deal with the prejudice piece. But if I recall, under Massachusetts law, if the prosecutorial misconduct is intentional, I believe prejudice is presumed. So you don't ever need to do the prejudice analysis if there is intentional misconduct by the prosecution, I think. I should probably check that before I'm speaking about it, but I was sort of surprised that that the defense didn't raise a bigger ruckus about that earlier. Okay. No evidentiary hearing on Tuesday. It's just arguing about the harm, prejudice. So we'll see if
instead of
the
having a hearing without Proctor and Lally this time. Oh, yeah.
less exciting, but it'll still be interesting to listen to regardless. It's pretty wild, that whole situation, and the way it's all taught. I mean, it's just one more thread that the Karen Read case pulled that is leading to serious substantive consequences.
I mean, they let this kid out or guy, whatever you want to call him. That kid, what's his name? The King guy.
Miles King, the defendant,
Yeah,
and
Miles King. Miles King. They let him out after like 3 years, but he's up on murder. He's up on murder, shooting somebody right in front of their mother's house, and they let him out on bail because of this. I mean, that is like real life consequences. Like that wouldn't have happened. Like that just because of Proctor and Lally and all their screw ups. And I just look at like they have this police officer who got shot by one of her own fellow officers while they're trying to subdue her, take her gun. She was having a mental health crisis. And they're charging her. She didn't shoot anybody, and they're not letting her get bailed out.
Yeah,
That's
I'm
just
not.
outrageous to me. She didn't shoot anybody. This guy, Miles King, shot somebody, allegedly, killed somebody. They let him out. It's just like, to me, that's why I just shake my head at the justice system here. I don't understand it. I don't understand how someone has no bail. They didn't shoot anybody. The other person shot and killed somebody. Allegedly, he gets bail.
The only way that sort of these absurdities are going to stop is if the judges make them stop by imposing consequences on the prosecution. As a result, consequences on the prosecution often means consequences on the victim's family. That is horrible. It's horrible in any case, especially a murder case. I mean, the victims' families matter a great deal. They have been tortured, and they are going to be tortured further if the defendant gets off based on prosecutorial misconduct. But it does not appear that this conduct is going to stop unless there are consequences. And maybe you just need to start finding the prosecutors. Maybe that's enough to get them to stop. Okay, no one wants to pay $1,000, $2,000, $5,000 because they were too lazy to check their discovery checklist 5 years ago or whatever it is. That could be enough. But something, at least try something, so we don't have to have these ridiculous conversations about, isn't it crazy that they let someone with significant volume of evidence against them and for a murder charge out on bail because we didn't do our jobs. I mean, it's just insane.
Like that. Someone should get fined.
Yeah, that's a
Like
very...
if we had to let a guy out and he's up on murder charges because you screwed up as a prosecutor, you're paying a fine. Like that should just be a given, right?
It is a completely valid in the state of Massachusetts sanction for prosecutorial misconduct, for late discovery, that kind of thing. It is valid. It is an option that the courts have. Use it.
Yeah, like this is it right here. Miles King was in custody. Lally failed to provide 6 search warrants to defense for 4 years it took. And it's like, that's why this guy gets out. And they don't even say his name. Marquise Simmons is the kid who got killed. And allegedly he said Miles King's name as he's dying in front of his mother's house. Like, Lally didn't seem to give 2 shits about Miles King, about his victim, Marquise Simmons. Didn't care about the mom.
And Lally presented the search warrants at the grand jury, if I recall correctly from the hearing. He presented them. So there's the whole "I didn't have them from Proctor" excuse doesn't even make sense intellectually. It just doesn't make sense.
Yeah, you're getting a lot of praise too, Corri. I want to thank you so much for being here.
Well, thank you for having me.
I've been a fan of yours for a while, following your Twitter account. And when you said you would come on, I was like, oh my God, this is going to be awesome. And it's been great. Everybody's loved it. I'm wondering if is it okay to even say the firm that you work for? I know you're an associate over there. People were looking it up and they see how serious you are and your experience. Is it okay to say that stuff?
Yeah, I work for a firm called Parker Poe. We are southeastern from DC to Atlanta, about 300 attorneys. So it's a big firm. We do civil law and white collar. Criminal is really the only component of criminal law. We kind of say we don't do most criminal law and family law, but we do everything else. And I take my job very seriously. I love my job, but this Karen Read case has really taken hold of me, and I'm obsessed with it. Probably like most people who watch you these days, I'm obsessed with it, and I can't let it go if I wanted to. So here we are. Here I am filing lawsuits on my own, pro se, in the state of Massachusetts because I cannot let it go. I think it's so crazy what's gone on.
Yeah, it just kind of does take over our lives, all of us. Here's a question that came in. They want us to ask you. Can you ask Corri her just basic drive when it comes to this case or about Turtle?
My drive in this case? Yeah, I kind of said it. I mean, I definitely got sucked in initially because I read a little bit about this story, probably from Turtle, because it seemed clear that there's some level of misogyny going on that was enraging, and I watched it and some sort of misogyny or outsider situation, and it seemed that as we learn more, that both were true. And I'm not really here to, I just want people to follow the law. And I love the law. I love the practice of law. And I find it extremely frustrating when the law is not applied correctly, especially in this case. And especially, I mean, with the public records law, I mean, that is one of the few situations in which I can get involved in a case where I don't represent anyone. And so this is just, like I said, a labor of love, anger, spite, whatever you want to call it. We got to set something right because it seems like a lot of things have gone wrong.
There's no chance you'll move to Massachusetts, Norfolk County, and run for DA.
There is a 0% chance of that, but I will certainly keep my eye on that race. I'm invested in it as much as any Massachusetts resident, for better or worse.
Well, we really appreciate everything you've been doing for us in Massachusetts from outside of Massachusetts. It's much appreciated because you provide such good information, and like someone said, you're always ahead of the game. You really are. You always kind of foreshadow. You know what's coming next. So I really appreciate everything you've been doing on Twitter. We pinned it in the chat. I hope people follow you if they haven't already followed you on X on Twitter. Do you have any final thoughts or anything else that you want to bring up tonight that you didn't get a chance to talk about?
No, I just want to say thanks for having me, Mike. I appreciate it. I've appreciated everybody's engagement and interest in the law. And I simply just try to provide a little, additional insight into it. But it's really just folks staying engaged, learning about the law and understanding the way it's supposed to work so we can understand, how it's gone wrong. And then as the final step, how to fix it. I love that engagement. So it's been great. But I really appreciate you having me on, Mike.
Excellent. I got another question for you because you've been around now for a little while. Who are the people that you like to follow? Like any shows, any Twitter accounts? Who do you like to give a kind of shout out or appreciate a lot for what they've been doing?
Well, obviously, I love watching your show, Mike. I like a lot of the YouTubers. I started with Emily D, and turned to Melanie, and Nurse Kim has been an additional sort of. I wish I had discovered Nurse Kim earlier because God, she makes me laugh next level. I mean, I'm like spit my drink out 5 times during the show. So those folks I really like. I love the folks that provide a lot of factual information as well. Dee Dee's Suspicious Sauce on Twitter. She's always got the documents. I always appreciate that. That's kind of what I'm here for.
So someone was just asking for the Twitter account. It's pinned at the top of the chat, but I'll read it for you if you really want it. It's Nunya, Nunya 98 and then 57 9877777. I think I said that right.
You
But
did.
you got it. Yeah.
I made up some stupid fake Twitter a while back so I could, get hit back at Coffin Daffer and her misinformation during trial 1. And now I've just kept the name since then.
Yeah, and I'm gonna throw it in the chat one more time for people who don't know where to look at the top of the chat. If you can't find the pin chat, I mean that's a new one, but I'll post it again so I can share it on the screen as well.
Come on, Mike, make them work a little bit for it.
Yeah, they don't. Yeah, I want to make sure you get every one of them though. Like,
Okay.
I usually do give the viewers some crap, but not tonight. We just want them to follow you.
Fair enough. Well, I appreciate it.
I do go off sometimes.
True.
We're trying to make an easy class. I want to thank you so much again, Corri, for being here with the Young Jerks. That was a great show. I really appreciate her being here. And I did put her Twitter account, her X account up there. That was fun. That was good. I want to thank everyone who's been watching tonight. Thank you all the super chats. I want to thank Nick Starrow, who sent us happy Sunday, folks. May next week be filled with more disclosed email and lifted redactions. I think we're going to have fun at the hearings. We get some court hearings on Tuesday and Wednesday. Aiden's going to be in court on Wednesday, and on Tuesday we have the Miles King hearing. So you get Rosemary back in court. I want to thank Sheila's TCC. I want to thank Kat. Thank you so much, Kat Randall. And Me9. We did ask that question earlier. Thank you so much. Thank you for the super chats tonight. We got three super chats came in. That was a great guest. A first time guest. I always like first time guests. You know what I'm gonna do? I want to end it. We're gonna play Trooper Paul. We talked about it. Why not just go to Trooper Paul? This was the best cross. It's like 2 hours. We'll be going all night. I don't even care. Why not go back to Trooper Paul tonight? Why not? While we're gearing up. Oh, I just had it up and I went to the. Hold on 1 second. Let me make sure I got it. Okay, here we go. I have it right here. We're gonna tee up Trooper Paul one more time. And I'm gonna skip. What I'm gonna do on the Trooper Pauls, I'm gonna skip when Lally talks to him. I'm gonna get right to when Jackson takes over. I can't listen to Lally.
Sorry. The vehicle accelerated at a high rate of speed before she struck the pedestrian John O'Keefe on the roadway and subsequently left him at the scene.
And with respect to the backup safety system that you observed in this vehicle.
Yeah, I told you I'm gonna skip over Lally. We gotta skip
Lally.
Lally. We can't listen to him at all.
Played in how this crash occurred.
This is too much. This is
Based
too
on the
much. Here we go.
Degrees in the scientific discipline of biomechanics.
No.
Thank you,
How
Jersey
about
Jen.
in engineering?
No.
How about in kinematics?
No.
What's the highest degree that you do hold, sir?
I have an associate's degree.
In what?
Administration of justice.
You mentioned kinematics on Friday. Do you hold any certificates in the specific area of kinematics?
Yes, it's covered in the basic crash investigation classes.
Okay, so you took a class, in other words, correct?
At multiple classes.
They introduced the idea of what kinematics is, right?
Correct.
Testified about that on Friday.
Yes.
Define kinematics, George.
It deals with the aspect of motion.
It's a subfield of what broader field?
Kinematics.
Kinematics is a subfield of what broader discipline of science?
I'm not sure.
Big physics, correct?
Yes.
And it describes how points and objects and systems of objects, how they move and how the rate they move and the rate of their velocity, correct?
It deals with emotions.
What's that called? The rate of velocity. What's another word for that?
The rate of velocity.
Correct.
I mean, it deals with the motion. It deals with forward, and also deals with speed. It deals with travel and speed. If something's moving, it also has a speed to it.
Right. The word you're looking for is acceleration, correct?
Sure.
What role does acceleration play in the field of kinematics?
What role does acceleration play in kinematics?
Correct.
It talks about, like you just said, it talks about the speed and talks about motion.
Is kinematics also known as the geometry of motion? Is that correct?
I have not heard that.
Never heard that. What's the difference between constrained and unconstrained motion?
Constrained and unconstrained motion.
That's what I asked.
Constrained motion. I can't recollect at the moment.
Constrained motion is motion on a predetermined path, isn't it?
Yes.
Unconstrained motion is what?
When it doesn't have a predetermined path.
Free movement, correct?
Correct.
Can you remember that from your class?
For the most part, we don't go that in depth, constrained and unconstrained.
Constrained and unconstrained, not restrained.
That's what I said. Sorry, unconstrained. Yes.
Kinematics uses algebraic formula to model these motions, right? The motions of these points, systems of points, correct?
Yes.
And it includes concepts like displacement and speed, velocity, distance, acceleration, which we've talked about, correct?
Correct.
And it looks at how these things, these values vary over a point in time or duration in time. Is that right? Do
Yes.
you actually understand the physics behind the study of kinematics?
Yes.
The word you learned in class.
Yes, we had to go over the physics part of it.
On Friday, you said that this incident is a pedestrian strike from a vehicle. You reiterated that again this morning. Is that right?
Correct.
I want to be clear, that is your opinion based on your training and experience, correct?
Yes.
And on Friday, you said you based that opinion on the fact that you noted a half-mile-an-hour decrease in speed and a steering input of less than 10 degrees at some point in that reverse motion, correct?
I said that was consistent. That data point in general was consistent with something that you would see within data of a pedestrian striker striking something else. I do go in my report saying I can't say that's definitively where a pedestrian was struck, but
I'm sorry, I can barely.
it wasn't definitively. Sorry, in my report I do say I can't say that is definitively where the pedestrian struck.
You cannot say.
Definitively, yes.
Okay, so you're going to have to slow down and speak up, okay?
All right.
You just said, I just want to make sure I'm hearing you correctly, and I apologize.
Okay.
You said you cannot say definitively that that resulted in a pedestrian strike.
That data point within the text stream data is what I'm talking about.
Okay.
That specific point, that time frame.
Because there's a multitude of reasons why when someone is driving in reverse, they might slow down by a half a mile an hour, right?
It's when I say when it's consistent, it's because there's the other aspects of it is the fact that the accelerator is consistently strong.
Let him answer. Finish your answer.
So the accelerator is consistent at a constant rate, and then it just drops by half a mile, and the steering wheel all of a sudden abruptly goes to the right. That's what I'm talking about when I say it is consistent with a pedestrian strike. That's something that you would see. It's not going to be a huge change of speed during this collision.
You also note that at the time, it had begun to snow, correct?
Yes,
There would be snow on the lawn, right?
correct.
There would be snow on the cars,
Yes,
snow on the trees,
yes,
snow on the roadway.
yes,
Snow on the roadway could impact how tires move over the roadway, correct?
in a way.
And obviously, there are a multitude of reasons why somebody might input a 10-degree input on a steering wheel, right?
Correct. That's why I said I couldn't definitely say it.
Right. So every time somebody slows down, going in reverse or forward, and introduces a 10-degree input on the steering wheel, doesn't mean they're looking to hit a pedestrian, correct?
Correct.
You testified that you determined the area of impact by basically following, if I heard your testimony correctly, basically following the debris field from the body from where you believed John O'Keefe's body's final resting place was, almost linearly to the furthermost piece of debris that was found. Did I get that right?
Yes.
In other words, you established what in your mind, or what you were told was his final resting place, and what you were told was the debris field. And you indicated that the furthermost piece of debris would basically be the area, right?
It's within that line. I didn't say that is the area impact where the furthermost piece of evidence is.
All right.
It's just the linear, like you said earlier, it's that linear. We're going that path. That's the path that he traveled post impact with the vehicle.
And that is on which that fact that you stated is on which it's a terrible question. That's the basis for your opinion of where the area of impact was, correct?
Yes.
Let's take a look at exhibit, with the court's permission, 587. It's your diagram 3. If I may approach you on it just for.
Okay.
May I approach?
Yes.
Your Honor, may we publish Exhibit 587?
Yes.
Diagram 3. Okay. Sir, you see diagram 3 on the board. You also have it in front of you, correct?
Yes.
It's easier for you to refer to what's in front of you because that's a little bit further away. Just let me know.
Okay.
The red arrows adjacent to the blue writing, where I'm highlighting right now, indicate basically the debris field that you explained to the jurors on Friday, correct?
Yes.
And then there's a point of an arrow that comes back to a wording that says pedestrian's final rest, basically right there, correct?
Yes.
And the debris field ends right in the middle of that spotlight, correct?
Yes.
All right. So that's the area of impact that you indicated to Mr. Lally you believe occurred because of the debris field and the linear portion of that debris field going from the pedestrian's final rest all the way out to that final little red arrow that says red plastic B in parentheses, correct?
Yes.
Donna, can we have Exhibit 492 published to the jury, please?
Okay.
Approach.
Yes.
While that's coming up, have you ever seen this?
No, I haven't.
Take a look just above the arrow. Your Honor, with the court's permission, maybe highlight or magnify the area just above the arrow.
Okay.
You see that
Yes, I do.
right underneath fire hydrant, correct?
Correct.
What does that look like to you?
Piece of plastic.
It's debris, correct?
Correct.
All right. Can we go back with the court's permission to Exhibit 87?
Okay.
Diagram 3. You see the fire hydrant?
Yes.
Fire hydrant's right there, correct?
Correct.
That's another, according to your scale, that's probably a good 30 feet from the pedestrian's final rest, correct?
Yeah, that's about right.
So that is the furthermost in this diagram, the furthermost piece of debris on the diagram, correct?
Correct.
So now your testimony changed that this, in fact, is the area of impact.
No,
Why not?
because it's just a piece of debris. I'm talking about the path. You follow the path of debris field. Debris can move and change.
The debris doesn't fly backward, does it?
I'm saying you pointed to like just the fire hydrant as the area impact for the debris where that one piece of plastic was, saying that's the area impact is right next to the fire hydrant.
Are you asking me a question?
Yeah, and that's what you said, right?
I'm asking you,
I'm making sure I'm understanding what you're saying so I can answer the right.
Ask the question again, Mr. Jackson.
in fact, you indicated on Friday that your analysis of the area of impact was predicated on, based on, the furthermost piece of debris from the pedestrian's body that you were aware of, which is right there. Red plastic B, correct?
I said it's well, I said you said earlier with the linear equation. I mean, it might have moved it over more, but it's the debris, the start of that debris, the one that is. I can't say that's definitely the point of area impact or the point of impact.
You can't,
I just-
can't.
I cannot say that is the point of impact right there. You just kind of follow the linear path because they have to follow in a direct path that way.
Okay, so now your testimony is that's not the area of impact.
I never said that was the area impact. I said it's after that.
Trooper, we were all here on Friday.
Okay.
That's exactly what you said under questioning by Mr. Lally, wasn't it?
Objection.
Sustained.
Didn't you say on Friday that you determined the area of impact for Mr. O'Keefe, the point of impact was red plastic B because that was the furthermost piece of debris you were aware of from the final point of rest from Mr. O'Keefe's body, Isn't that what you said?
I don't believe that's my exact words.
Okay, I'm not asking if it was your exact words. I don't have a transcript of it. I'm asking you, is that what you tried to impart to the jurors?
What I said to the jury, I said after that. That's the start of, that's the last point of evidence that I had. I said the area impact is probably along the roadway after that point. I mean, like before it, if you have to walk towards him.
I'm sorry, I keep doing that because I think you're done. Are you done?
I am done now, sir.
Now you're aware that there's a piece of debris, looks like taillight material, right under the fire hydrant, correct?
Correct.
If the area impact, which you indicated on Friday was where this red plastic B is, you would be wrong, right? Your analysis would be flawed.
No, because that's not what I said. I said it's along the roadway, and it's going to be after that point.
Okay, so is the area of impact now where the fire hydrant is?
Objection.
Ask it differently.
Are you now indicating, because now you realize that there's a piece of debris directly under the fire hydrant, are you now indicating that that's the area of impact where John O'Keefe's body was struck?
Objection.
Sustained.
Let's take a look at exhibit, with the court's permission, 279.
Okay.
Take a look at exhibit 279. I want to draw your attention to that piece right there, okay, of plastic. You see it?
Yes.
You describe it for me. Just physically, what does that look like?
Looks like clear plastic with a little bit of red and the black on the top part.
Okay. Maybe in a triangular shape. Is that fair?
Correct.
Okay. Now, if we could go back to, with the court's permission, exhibit 492,
Okay.
and highlight just above the ruler. How would you describe that piece of material?
It looks like the same piece.
Does that, based on that, does that appear to be part of the taillight material that was found at the scene?
Correct.
Okay. Now, based on that, are you now suggesting, if we could go with the court's permission, if we could go back to 587, I'll stop jumping around just a second. I think we
Okay.
just get back to 587. Oh, sorry, the diagram. Great. Okay. Now, seeing what you just now seen in terms of that piece of plastic that appears to be from the taillight, does that appear to be under the fire hydrant, which is highlighted? Same piece.
Yes.
Okay. Based on that, does that change your opinion? Is that now, the fire hydrant now the point of impact?
No.
Where is the point of impact now?
It's along the roadway. I don't know the exact point of impact.
So you don't know the area of impact?
I said the area impact is along the roadway after the debris.
Okay.
I mean, only thing it would change, only thing it would change is maybe it's a little further away. But besides that, it's a linear field. I'm not talking about like one point. It's, you kind of follow the middle of the debris field, and that should be the path.
Well, if the point of impact is along the roadway, where along the roadway, you can show the jurors, where along the roadway, in your expert opinion, was the point of impact?
It should be within, if you follow from pedestrians, find a rest here, just kind of follow back. That's what I'm talking about, linear field. I can't.
So now you've indicated an area, I can follow your laser pointer, an area along here, correct?
Yes, somewhere in there.
All right, if I have my spotlight, is that, if I leave it right there, is that about where the middle of the spotlight, about where you believe the area of impact is?
It's within, I guess you can say it's within that area. I don't know, definitely there's nothing on the roadway that has a definitive point that says this is the area impact right here. It's within the roadway based on the evidence at the scene.
Okay. Mr. Paul, sorry, Trooper Paul, I'm asking you, based on your expert opinion and your conclusions, based on your full analysis, can you point me to within an area of 5 feet or so on the roadway where you believe the area of impact is. Is my spotlight basically highlighting the area that you believe, in your opinion, is the area of impact?
Do you have that laser pointer?
I do.
Why don't we let him show you? It'd be easier for the jury to see.
So what I'm trying to say is, so we follow the linear path back around this area.
Okay, can you?
And sorry, I'm trying to keep it straight as much as I can. Follow back to here. I can't say like if this definitely is, but it's possibly based on also vehicle damage to the back of the vehicle. So if we follow all the way back to here, that could be a possible area impact.
So when you say that area there, just I want to be very clear for the record that what you highlighted is an area basically just to the left of an X that's on the roadway, on the bottom of diagram 3, toward the lower part of diagram 3.
It's
Correct?
you would use your circle almost to kind of be a good area around.
I'm sorry.
You can use a circle around here. This would be around the area.
Okay.
Okay.
So using your scale, that scale is going from full left to full right, it's plus or minus 40 feet, right?
Switch. Can't see it. So say again. Say the question.
That scale is 40 feet, going full left, full right, 40 feet.
It's 40 feet. It's a 10-foot scale.
Okay, sorry, 20 feet, my mistake.
I was okay.
Eyes are terrible. 20 feet, thank you. All right, so if you use that scale, can you estimate for the jurors? I'm just going to use this X as a starting point. Can you estimate for the jurors from this X that I've highlighted, the pedestrian's final rest? What's that number? Doesn't have to be exact. Give me an estimate.
So, I mean, it could be within 30 feet because I tell you this also on my scale, this 2 and 3 is 50 feet from each other.
Is how much?
50,
Okay. 50.
50.
So would you agree that from this X down here, to pedestrian's final rest, as the crow flies, that's probably a good 35, 40 feet.
I mean, I could try to use the scale, but there's me the scale.
If you wouldn't mind. You need a piece of paper?
Yes, please.
Court's permission?
Okay.
Just a blank piece of paper.
Thank you. Yes, thank you.
You need a pen?
I got one. Thank you. It's a little around, it's approximately 30 feet.
Approximately 30 feet.
Yes.
Can you place, with the court's permission, can you estimate 30 feet in here?
Can I ask?
Can you point to a place in the courtroom that looks like it's 30 feet from you?
Objection.
No. Next question.
Does the court have a diagram of a diagram of distances?
In this courtroom? No.
You indicated just now, and then I'm finished with this. Thank you. Thanks. You indicated just now in answer to Mr. Lowry's last couple of questions that in your expert opinion, when the SUV struck the pedestrian, John O'Keefe, he was, quote, projected forward and to the left to the front yard to his final place of rest.
Yes.
So your expert testimony is that John O'Keefe was hit with the SUV and flew 30 feet.
Projected mean like I don't say he flew all the way there. He was projected in that way. He got pushed forward in that direction.
Which he was rendered incapacitated, landed there, you have to sort of fly there, right? You can walk there.
I mean, would you definitely flying like literally off the ground the whole entire time? Or,
Well, you tell me, you're the expert.
I mean, he got when we say projected, we mean he gets projected, and they usually have a landing phase, and they land, and then they either roll or tumble to file and rest.
Okay, how far do you think he landed? How far was it until he landed of that 30 feet?
I don't know. There's no indication of where his exact landing spot was.
Is there any evidence whatsoever that he landed and rolled?
And there was no evidence that he landed or rolled. Or rolled.
According to you, the evidence that you have in front of you is that you get hit, fly 30 feet, land where he ended up in his final rest, right?
Objection.
Sustained. Ask it differently.
Based on your expert opinion, you believe that he was projected through the air to his final rest place.
That's not what I was saying.
But you said there's no evidence that he rolled.
And there's no evidence that he flew through the air either.
Exactly. Right? Exactly.
Objection.
Sustained.
You said on Friday that in your experience, people tend to lose objects that are not strapped to them. Is that right?
Yes.
In other words, get hit by something, car, truck, bus, whatever, train, and if you have something in your hand, boom, you lose it, you drop it. If it's not strapped to you, correct?
Correct.
How do you suppose that Mr. O'Keefe, in your opinion, held on to that glass cup that was found right next to him over the course of 30 feet being projected?
Objection.
I'll allow it. Do you have a theory on that?
I don't know. I mean, it just could have been with him the whole way. I don't know. I wasn't there, so I don't know how the glass stayed with his body and went with him to the final rest.
So I mean, it's just common sense. You have to believe it. It was in his hand. He held on to it the entire time it was being projected 30 feet, correct?
It's possibly, it could have been in his hand. It could have been tucked next to his clothing. Did
you say tucked into?
I mean, like, could have been next to his body. So when he projected, the glass was with his body as it was also flying. So there's a number of reasons why the glass, because it also got projected with the body while he was holding it.
I thought you said on Friday, and you just agreed with me, that people drop things when they're hit.
Yes, bodies think not everything it tends to fly off. I mean, some stuff flies off, some stuff will stay on.
I see.
It's not uncommon to find piece of clothing and stuff, that you find at the scene.
Piece of clothing?
Like clothing, like shoes, like shoes and stuff like that to come off the body during a pedestrian crash.
Well, that's not what I asked.
I know, I'm just saying, you asked me, you said what I'm just responding to what you said. And trying to make sure you understand what I'm saying.
No, I don't, but I'll
Yeah.
ask another question. Shoes are strapped on by definition, right?
Yes, but it's very common for shoes to come off.
How about a cell phone?
Cell phone, yeah. Yeah, it depends on where it is.
It was under his body.
Okay.
How do you account for that? He held onto a cell phone with one hand and held onto the cup with the other.
Objection.
Sustained. Ask it differently.
If the cell phone was found under his torso, under his body, what's your theory on how that cell phone ended up flying 30 feet with it?
It just did.
Just did. And somehow, as he landed, tucked that cell phone underneath his body so he landed on top of it.
It just did. That's the evidence at the scene. I didn't put the evidence there. So
Well, you didn't.
Objection.
All right. So jurors, I've told you before, lawyers cannot make comments. So disregard it. Mr. Jackson, don't do it again.
I understand. So in
You
one-
understand, but don't do it. Your answer is always, I understand. Don't
Yes,
do
Your
it.
Yes, you are. Cell phone in one hand, cup in the other hand, flew through the air, right?
Objection.
Sustained.
You were informed of this incident on January 29th, 2022 at about 2:30 in the afternoon. Is that right?
yes,
At the time, you were working out of the CARS facility, which is located on West Grove Street in Middleborough. Is that right?
yes,
By the way, that's a facility that has multiple garages. Sally ports, I don't know if they're called Sally ports, but garage bays, correct?
the mechanic shop are there.
The mechanic shop
Yes,
is, if you're going to review, for instance, for purposes of reconstruction, if you're going to review a vehicle, Is the vehicle placed in those mechanics bays?
No, not there. That's for state police vehicles.
Okay, so where are the mechanics bays, sorry, reverse that. Where are the sally ports where you do your analysis, your reconstruction, your review of the vehicle, inspections, things of that nature?
We don't have sally ports for that.
You don't have anything dedicated to that?
No, the only time we would use a sally port is the crime scene would have some sally ports that they would do to document their crime scene stuff. And I've gone there to do my inspections, but most of our inspections are done either at the tow yard or some type of facility for that.
Ultimately, was this SUV ever taken to the Middleborough facility?
Yes, it was.
Where was it placed?
There's a fenced in area inside it's a fenced in area
Is it outside or inside?
outside.
Okay. Did it remain outside in that fenced-in area the whole time?
I don't know the exact time. It was there for a while, then it got moved.
Where did it get moved to?
I'm not sure exactly where they moved it immediately after it left Middleborough.
Are you familiar with the Foxborough location?
Yes.
Does that have sally ports or bays for inspection and evaluation?
It has garages in it, but we wouldn't use them. We don't normally use those garages for inspections.
Is it possible to use those garages for inspections?
It is possible.
Okay. It's happened before, correct?
I've not used the inspection in the garages.
But it's,
I'm going to ask you to keep your voice up and
Sorry,
speak
yes.
slowly.
but you know they could be used.
Sorry.
You know that those bays could be used for inspections or analysis or evaluation if needed, correct?
Yes.
All right. Given the fact that the SUV that was being seized on January 29th was being seized as potential evidence, best practices would suggest that you want to get it in and out of the bad weather, the inclement weather, as quickly as possible, correct? You wouldn't want to subject it to continued forces from nature like rain, wind, snow, sleet, hail, right?
That would be beneficial, yes.
All right. You're aware that the Foxborough location and the Middleborough location with the mechanics bays are all closer to Dighton than Canton, right?
Both Foxborough and
Foxborough and Middleborough are both closer to Dighton than Canton. In other words, you have to pass by, depending on which way you go, pass by Middleborough, pass by Foxborough to get to Canton.
so from where?
From Dighton, sorry.
So from Dighton.
Where the vehicle was seized. In
Yeah.
Dighton, all going toward Canton, you pass by either Middleborough or Foxborough to get to Canton. Right?
I don't believe you'd pass by Middleborough to get to Canton, but you pass by Foxborough.
The car was not taken to Foxborough, was it?
No.
As a matter of fact, the car was taken basically double the distance all the way to Canton to that sally port, correct?
Objection.
Do you know that? Is that double the distance?
I don't know the exact distance. I know it was in Canton.
And you know it's farther to Canton.
From Dighton, yes.
Right. And you're also aware that because you've been to the scene, assuming, correct? The 3430.
Yes. Yes, I have.
And you've been to Canton, PD.
Yes, I have.
You know that those two locations are about 3-4 minutes apart.
Yeah, I can say that.
When you started let me ask this in a different way. Before you began any review on this case, any physical review on this case or analysis on the case, you were told that there had been a crash, correct?
Yes.
You testified to that at the state court grand jury in this matter. Is that right? That you've been told in advance this was a vehicle pedestrian crash and you were asked to analyze it, right?
Yes.
You wrote in your report that it was a single vehicle collision involving a pedestrian and you were, quote, assigned to reconstruct that collision, correct?
Yes.
So when you began your analysis, Trooper Paul, you were told conclusively by the lead investigator, Michael Proctor, that the deceased was hit by a car and your job was to reconstruct it. Is that right?
Objection.
Okay, so there are lots of parts to that. Break it down.
Sure. Were you told by Michael Proctor to reconstruct this incident?
Objection.
So were you told that by Trooper Proctor?
I was not.
Okay, next question.
Sure. Who were you told, who were you given your instructions by
Instructions for what?
to reconstruct this incident?
I wasn't given instructions to reconstruct it. It's just I was assigned to it.
Right.
That was requested. My assistance was requested to reconstruct it.
That's my question. Who assigned you to it?
I talked to my sergeant at the time who gave me the phone call.
And you were told some basics about that reconstruction, the event that you were asked to reconstruct, correct?
Yes.
The information that you were told came from the case officer. Is that right?
Who's the case officer?
The information that this was a pedestrian vehicle incident, as opposed to motor vehicle incident, pedestrian bicycle, motor vehicle motorcycle. You were told it was a motor vehicle pedestrian incident that you were asked to reconstruct, correct?
Yeah, I was told that, yes.
All right, and you had to be given some basic parameters of what that incident, how that incident occurred. Car was going in reverse, it's got a damaged taillight, things like that.
Some basic stuff, yeah.
What I'm asking is, I'm trying to get to is, who gave you that information? Where'd it come from?
That the car was traveling in reverse. Like, which part of the information? You asked me several different things just now.
Were you given information from multiple sources? Or did someone give you a summary of what you were being asked to do? At the very beginning,
Yep.
who gave you the summary?
Summary of the whole entire, of what?
Of the event that you were asked to reconstruct?
I was passed down when I got to the garage. That there was nobody that sat there and gave me the summary, like, that I can remember. I was told that it was a pedestrian crash. I knew it was a Boston police officer involved, that this was the vehicle, and that it was traveling in reverse. That's all they had.
Okay. What I'm asking is, that's great. Thank you for the summary. Who gave you that summary?
I don't know if it was definitely anybody from the get-go that was like I talked to.
From where?
I don't know if it's anybody that I could definitely say that was the person. There was multiple people going around when I got there. I think I talked to Trooper Zach Clark. He was doing the crime scene. I think he was Zach Clark. He was the crime scene photos at the time. I knew him from past crashes. He just said this is the vehicle, and I think he kind of gave me a little bit of a lowdown on what the vehicle was.
Okay.
So
My question is this: when you got that, did you call it a lowdown? He gave you the lowdown?
he gave me information. Yes.
Right. When you got the lowdown, you were told Boston police officer was involved, the vehicle pedestrian incident, car was going in reverse, and ultimately led to the death of the pedestrian. Struck the pedestrian in reverse, correct?
Correct.
All right. And you were assigned specifically to try to reconstruct that incident.
Yes.
Have you ever heard of the phrase confirmation bias?
I know the phrase. Yes.
You know what it means?
I can't definitely say what it means.
Developing a conclusion and then trying to find evidence to fit that conclusion. Does that sound right?
If you say so.
You noted in your direct examination that there were scratches on the passenger side rear bumper of the Lexus, correct?
Yes.
How exactly were you able to scientifically determine that any of those scratches were from an incident on January 29th, 2022, as opposed to any other time?
I didn't have anything else on the time. Is that those scratches happened prior to this collision?
I'm sorry.
I didn't have any information that those scratches were caused from a prior collision. And so when I looked at the evidence, I knew it was in that same area, the right rear tail light. So when I looked at it, it didn't quite fit the pedestrian thing. So when you showed me the video, or I saw the video like a year ago on Court TV, I said that could be.
You asked the question, so next,
I
keep
did.
going.
It's not responsive.
He's answering. Next
trying to-
question. Then
Yes,
go
I
ahead.
scientifically
Hold on.
thought the scratches were.
Hold on, ask
Sorry.
a question, Mr. Jackson.
You know what normal wear and tear on a vehicle is, right?
Yes.
Bumpers get scratched myriad ways, correct?
Correct.
Get scratched in a grocery store parking lot, right?
Yes.
Shopping cart can bounce off the back of the car and scratch the bumper, scratch the side of the car, quarter panel or something, right?
Sure.
I mean, I don't want to go through it, but there's thousands and thousands and thousands of ways that a car can get a scratch, correct?
Correct.
My question is, do you, as you sit here, do you have any scientific evidence that those scratches occurred on January 29th at approximately 12:45 a.m.?
What do you mean by scientific evidence?
Well, do you have any evidence whatsoever that you can point to that those scratches occurred on that date and at that time, rather than any other time in the history of that vehicle?
Like I said earlier, the video seems to appear that's what it looks like that could have been from.
Well, you said on Friday, let's talk about those scratches for a second. because
Yeah.
You testified Friday, you were pretty clear. You said that, if I can find it exactly. I may have just a moment, Your Honor.
Sure.
You said, quote, "The dent and scratches for his hand could be, those are consistent with striking the Lexus." Remember saying that?
Yes, on the tailgate.
Okay, so the dent and scratches you talked about on Friday, you said were from his hand.
Yes, hand in the glass cup.
Okay. Then are those the same scratches you're talking about in terms of the bumper?
No.
So,
What are you talking about? The scratch on the side of the bumper that we've been talking about?
correct.
Okay.
That's what I'm
No.
talking about. Okay. Is there any way to scientifically date a scratch?
No.
If you go out in the parking lot right now, even as an accident reconstructionist, you walk out in the parking lot right now and look at a Toyota Camry sitting there. It's got a scratch on it. There's no analysis that you could engage in to date that scratch, could you?
Objection.
So you can ask it differently, Mr. Jackson.
Is there any way that you could, in general, look at a scratch and say, that scratch is from such and such date?
Objection.
I'll allow it.
Nothing more.
I'll allow it.
You cannot say. You can look at evidence and shows that it may have been older than what the newer evidence would be, but there's no way to say that specific date and time and that a scratch would came from.
Right. And it's possible that any or all of those scratches on the Lexus could have predated January 29th, correct?
No,
That's not possible.
the ones that are on from the taillight and the other parts of it
Scratches anywhere on the car.
depends on what you got to pick the other scratches. You got to show me other scratches on the car.
I'm saying it's possible, since you can't date the scratch, it's possible that any or all of those scratches could predate January 29th. Simple question, right? It's possible.
You're being pretty broad on your scratches here.
I'm not being broad. Let me ask it a different way. Let me ask it again. Is it possible that any or all of the scratches noted on that car predate January 29th?
Any and all of the scratches? See, that's what I'm saying. You're being pretty broad. Any and all scratches on the car
Answer that question. If
that it
it's possible.
predate.
Objection.
I don't know every single scratch on that car.
Overruled. So can you answer that question?
No.
You testified that you noted glass on the rear bumper of the SUV, correct?
Yes.
And you said something about that glass coming from the cup.
Correct.
You also said that you did not see anything on that SUV that could be the source of those glass pieces on the bumper, right?
Yes.
When you did your reconstruction and your analysis, were you informed that none of the glass pieces, not one of them, could be matched to the cup?
I don't know anything about that. I don't know that.
So if you knew that the glass pieces on the bumper do not match the cup. That change your opinion
Objection.
about that glass?
Can you answer that question?
I cannot.
You can't answer the question.
It's what was told to me as evidence
Got it. By whom?
by the crime scene.
Who told you?
As crime scene that was there, it says it's glass from the cup. When I did my initial inspection, that's what it was on from.
That's not what you just said. You said that's what was told to me.
Yeah, by crime. No, yeah, I can see by crime scene. While I was at my inspection,
Wait, what?
it was told to me by the crime scene when I was at my inspection, at the initial inspection.
So what you meant by that's what was told to me is the crime scene talked to you.
Yes.
Crime scene say anything else?
I don't know what else you want me to say.
Did Trooper Proctor tell you that those pieces of glass on the bumper are somehow associated with the cup?
No,
Just the crime scene told you.
correct.
But if you knew that the crime scene was incorrect, and in fact, those glass pieces don't match the cup, would that change your opinion?
Objection.
Sustained.
Would it change your opinion in any way if you knew that the glass pieces do not match the cup?
Objection.
I'll allow that. Can you answer that question?
No,
I'm sorry, no, you.
I don't. It's a glass from a cup. It's a glass. It's not, it doesn't belong to the vehicle.
Right.
It's glass.
But if I told you it didn't match that cup,
What,
your opinion.
Objection.
Does that change your opinion?
are we talking, which cup are we never established which cup we're talking about.
How many cups have we been talking about, Trooper?
You said that cup, one at from the scene? Okay.
That cup? I'm talking.
I just want to make sure that we're on the clear path here. On the clear what we're talking about.
Absolutely.
Okay.
Really sure.
All I said, it's
It was found next to John O'Keefe's body in the snow at 34 Fairview on January 29, 2022. You got the cup in mind?
yes.
Okay. That's the cup. When I say cup, that's the cup.
Okay.
Would it change your opinion if I told you that the glass pieces on the bumper don't match that cup?
What's my opinion on it? All I said was glass from a cup. That's the only opinion I have. It's glass from a cup that was on a bumper.
Are you saying a cup?
A cup. A cup. It's not glass from the car. That was my opinion on it. I never said it matched to the scene.
You didn't.
I never said that in my thing. I said it's glass from a cup.
Okay. It's safe to say you didn't do any testing to determine the forces necessary to shatter a taillight on a 2021 Lexus 570, correct?
I did not do testing.
Your report indicates, we've talked about this a little bit. I'm going to go back to something we talked about earlier this morning. Your report indicates that John O'Keefe came to his final resting place about 7 feet from the roadway, and that's what you based your diagram on, correct?
Yes.
Who told you that number?
I measured it from my diagram.
You should say that again.
I measured it from the diagram.
Okay, what I'm asking is how did it get on the diagram? In other words, who
Oh.
told you that his body was 7 feet from the roadway?
Well, wait, I was told by Lieutenant, was it Gallagher, Paul Gallagher, Captain PT. He told me this is where the body was found. So I used my devices to mark that location.
Okay, but before you used your devices, he just pointed someplace on the ground and said he was about here, correct?
That's correct.
Did Lieutenant Gallagher tell you that Lieutenant Gallagher never saw John O'Keefe in place at the scene? Did he say that?
No.
Did Lieutenant Gallagher tell you that the first officer on the scene estimated his body at being approximately 15 to 20 feet from the roadway?
No.
If he had told you that, That have changed your diagram?
Objection.
He told me this is where he was found. I marked that location. That's all that was.
And you marked basically every other piece of item, sorry, that's a terrible question. Every other item you marked based on a distance from where you were told John O'Keefe's body came to rest, correct?
Yes,
Again, that was by Lieutenant Gallagher just pointing at the ground and saying it was about here.
correct.
Was there a single member of the team that was out when you were being shown where the body came to rest? Was there a single member of that team who actually said they saw John O'Keefe's body in place?
Objection.
I'll allow it.
What do you mean team? Canton PD?
Whoever was there, who was there with you when you started doing your measurements, et cetera? Report fair to you.
It's Lieutenant Gallagher. That's who.
Just you and him?
And myself and I was training a trooper at the time. She was there.
You were training a trooper at the time?
Yes.
Okay, so just, my mistake. I assumed that there were several people out there, just you and Lieutenant Gallagher.
Yes, that's why I was confused by the team.
All right. And again, Lieutenant Gallagher didn't tell you that he never saw John O'Keefe's body in place.
No, I don't think so.
You did document in your report that the items that you noted on your diagram that we just looked at a few minutes ago, those were found by the CERT team, correct?
Yes.
And you indicated in your report that the members of the CERT team located a single Nike sneaker that's noted on your report. Is that right? On your
Correct.
diagram, right?
Yes.
You also indicated that, quote, in the same area, 2 red plastic pieces and 1 clear piece of plastic of a taillight was discovered.
Yes.
So your report is clear that in total, the items discovered by the CERT team on January 29th were a shoe, right?
Yes.
A partial glass cup broken, correct?
Well, it was that on there. I can't remember if that's on their diagram or if that's what I was told at the scene, but yes.
Sure.
Yes.
You knew that a cup was found.
Yes.
Or you were told a cup was found.
Yes.
And 3 pieces of plastic, 2 red, 1 clear.
Yes.
Not 5 pieces of plastic, correct?
Correct.
You then measured those items, is that right?
I didn't. What do you mean measure them? Like
Measured
at
them
the.
relative to John O'Keefe's final place of rest. 10 feet from it, 12 feet from it, we're gonna go over the numbers.
Yes, I used their report to place those items onto my diagram.
So, and then I'm gonna get to that question in just a second. I wanna make sure that we walk through it sort of methodically. You then use some calculation, some tool or something to measure distances. Like there's where I assume John O'Keefe's body was. Here's a final rest place. I'm going to use that as point A, and then I'm going to measure from there and go 7 feet to where the shoe was found, or the first red plastic piece was found, or whatever, right?
Yes.
Who told you where the pieces were found?
They were in Lieutenant Tolley's report. He put measurements in his report.
Okay. And you noted that the shoe was 9 feet.
Yes.
And you put that in your diagram.
Correct.
You noted that the glass cup was 1 foot from John O'Keefe's body, correct?
Correct.
1 foot is about that long, right?
Yes. It was. They basically said it was found next to him.
Right.
Yes.
A piece of red plastic 7 feet from John O'Keefe's body, correct?
Correct.
A clear plastic piece 10 feet from John O'Keefe's body, right?
Yes.
And a red plastic piece 12 feet from John O'Keefe's body, correct?
Correct.
What part of his body were you measuring from?
Like center of mass.
So he's 6'2".
Yes.
Did Lieutenant Gallagher tell you where his center mass was?
No, I measured from. He just said he was here, so I try to put like where his head, where his feet, and try to measure the middle between those two.
So ultimately, because Lieutenant Gallagher was not at the scene when he was found, Lieutenant Gallagher had to sort of guess where the body was found, correct?
Objection.
Sustained.
You had no photographs of John O'Keefe in place, correct?
Correct.
There were no establishing shots, and there were no perspective shots, correct?
Correct.
There were no relative shots, meaning this is relative to that, I can measure that and figure out distances, correct?
What, like from a picture?
Yeah, so you know how that's done in science, right? You want to find out a relative position of something, so you take 2 or 3 or 4 shots. You know that something is never going to move, like, I don't know, a flagpole. You can measure from there.
Sure.
You get cross coordinates, right?
Sure.
Left and right, and where the 2 coordinates match, that's where the item is, right?
Correct.
None of that was done, right?
From the pictures?
None of that was done to do your measurements.
I use, like I said, I use the measurements from, measured on my diagram in itself, and I measured from those points off my diagram.
Right, but the starting point was a guess, wasn't it?
Objection.
Sustained.
Did you have to sort of guess at where you thought John O'Keefe's body was?
I didn't guess where his body was.
Did you guess at his center of mass?
Objection.
Did you guess?
I did not guess.
Next question.
You stated in your report that you Google mapped Miss Read's path of travel. Well, let me ask you a different question. If I could withdraw that question with the court's permission.
Yes.
Your diagram has all those arrows pointing at specific locations, very, very specific, very thin arrows point, correct?
Yes.
If you start off with an incorrect assumption about where John O'Keefe's body was, right? Hypothetically, if you were to start off with an incorrect assumption where John O'Keefe's body was, every single item that you note on that diagram would then be off as well, wouldn't it?
Objection.
Is that true?
I mean, I guess hypothetically, depends on how off you want to be.
And the answer is yes, correct?
Hypothetically.
You stated in your report that you Google mapped Miss Read's path of travel on January 29th based on what you determined to be, quote, it's likely the two, and you said that it's, quote, it's likely that the 2 events, meaning the triggering events, occurred at the same time the Lexus was at 34 Fairview at the time of the collision, correct?
Yes.
The first triggering event is what? Was it a 3-point turn or a U-turn? I thought I heard you say both.
I guess it would be more, 3-point turns, essentially. I guess it's a 3-point turn.
Okay.
Yes.
Well, did you say U-turn on Friday? I just swear I heard that.
It could have been a U-turn. I mean, it's still turning around. So you had to make a U-turn when that's a 3-point turn or not, but it's still.
Okay, but not to be picky, but it's sort of my job.
Okay.
A U-turn, traveling in one direction, turning, right? Turning the wheel, never changing gear, since it's reverse or anything, just turn it, right? A 3-point turn requires moving forward, stopping, changing gears, moving backward, stopping, changing gears, using steering input, and then moving off, correct?
Correct.
Well, those are 2 very different maneuvers, right? You agree?
It's, in a sense, I was trying to say she made a U-turn. Like you can say they made a U-turn. It's a 3-point turn. They're still making a U-turn. And I didn't mean it as like she literally had to make a direct U-turn. She was turning around. And obviously the diagram, or the trigger shows a 3-point turn.
Well, I mean, I guess you could have said reversing direction, right?
That could have been a better way to say it, yes.
You didn't say that. You said U-turn. So are you changing your testimony from Friday that it was a 3-point turn, or could it possibly have been a U-turn?
It's a 3-point turn.
Okay, because you have evidence of the starting, stopping, changing gears, reversing, stopping, changing gears, turning.
That's correct.
Okay, so when you said U-turn, that was inaccurate.
Objection, Your Honor.
The objection sustained.
Let's get back to the path of travel when you began your analysis. How did you know what the Lexus's path of travel was that day?
I got the directions from Trooper Proctor.
And what did Trooper Proctor tell you in terms of the path of travel specifically? Starting point and an ending point, tell you the exact path Alexis traveled.
No, all I got was mostly just the addresses.
Okay, so if you've got 2 points on a map, and Trooper Proctor told you Alexis traveled from point A to point B, there are multiple ways to get from point A to point B. You'd agree with that, right?
Yes.
You picked one of those, right? The path of travel includes freeways, et cetera, right?
Yes.
But as you sit here, you don't know what her actual path of travel was, because it could have been something different, right?
It could have been something. That's why I gave a range on my diagram.
Do you have any scientific evidence to establish what her actual path of travel is, or did you just guess at the path of travel?
I got the addresses from Trooper Proctor. I put them into the thing, and then one of the possibilities of 36 miles, and that was after looking at all of them, at 36 miles is a possibility.
Right, understood. So that's what I'm trying to get to, Trooper Paul.
Okay.
That's one possibility. There's 36 miles,
Mhm.
one route of travel, right?
Correct.
There are other possibilities, right?
Yes.
So between and among the possibility that you picked and the other possibilities, you just sort of had to guess. And there's no science to it. You said, I'm going to pick that one and put it in my report, right?
No, that's not how that worked.
Okay, why don't you tell me how that works?
Her odometer mileage on the car from the download and time we had the vehicle shows 36 miles. So when I plugged those addresses into Google, it came up as 36 miles as a possibility.
And you knew that there was another route of travel to the same location, correct?
What do you mean?
There were alternative routes of travel to the same 2 points, from and to the same points, correct?
Yes. Yes.
You could have tried to extract the location data from Ms. Reed's cell phone to determine the exact route of travel, correct?
I don't know. I don't have access to do cell phone extractions.
So that answers my next question. You did not even attempt to do that, did you?
No.
You did attempt to analyze the key cycles for the Lexus in order to determine placement of that vehicle. You just talked about that with Mr. Lauper, right?
Yes.
I want to be clear for the jurors because most people have probably never heard of key cycles. A key cycle does not have any location data associated with it whatsoever, does it?
Correct.
It just shows you when a vehicle is turned on, the ignition is on and off. That's one cycle, correct?
No.
Tell me what I've got wrong.
Key cycle of the car doesn't have to be turned on.
Say that again.
It goes from off to run. The engine doesn't have to be started to off.
Understood. So if it turns on, well, every single ignition is a key cycle. Every time the engine turns on, that's absolutely a key cycle. Once it's turned off again, right?
That gets recorded as an ignition cycle.
Right. So a key cycle can be an ignition cycle, but it doesn't have to be an ignition cycle. It also can be just turning the sort of accessory on, right?
The key cycles turn the accessories on.
All right. But it doesn't, my question was, and where we started with this conversation is, it does not have any location data on it whatsoever.
Correct.
All right. So when you drive your car, you walk out, get in the car, turn the ignition on, start to drive, get your location, turn it off. That's one key cycle, right?
One ignition cycle.
But and I'm going to use the word key cycles because you use the word key cycles in your report. That's what we're talking about.
I'm using that because that's how the trigger was read.
That's how what?
The triggers were read on the text stream. That's how they read them, key cycles.
By key cycles.
Yes.
I'm going to use that phrase key cycle.
Okay.
We're talking about the same thing. It's an ignition on, ignition off cycle.
Doesn't have to be on.
So you mean the engine doesn't have to be turned on?
Correct.
Right. But if you're seeing triggering events, not trying to be tricky here, seeing triggering events, the car's in motion, What does that tell you? The ignition's on or off?
The ignition is on.
Right. That's what I'm getting to. But it has no location data associated with whatsoever. It could be here, it could be in Wyoming. The car wouldn't know the difference. It's not going to report the difference to you, correct?
On the key cycle,
Correct.
on just the key cycle. The key cycle does not give out locations.
Say that again?
The key cycle does not give a location.
Right. So your analysis is trying to go from a known key cycle that you can figure out and then work backward from there to try to figure out where the car was on a particular ignition cycle or key cycle, correct?
I didn't use the key cycle to put it back.
Say that again?
I did not use the key cycle to place the car back in its location. The key cycles were, all I got from the key cycles is that they occurred close within proximity to the time we've had the vehicle, not basically saying that this was the location based off the key cycle.
Well, let's look at Exhibit 591 with the court's permission.
Okay.
Did you testify on Friday that this is a copy of the exhibit that was put in 591, this is part of your report, correct?
Yes, it is.
And this is a chart that shows when move to this arrow. That arrow indicates top and bottom where your testing occurred, correct?
Yes.
Okay, we move over to the left. That is key cycle what?
1164.
Right. So you've testified, and we can turn the lights on. Your Honor, I don't mind if that stays up. You can turn the lights on. I don't think it hurts anything. You stated in your report that there were, quote, 2 triggers recorded on odometer 12629 and key cycle 1162, correct?
Yes.
These events were prior to the testing triggers on odometer readings 12665/12666 and at key cycle 1160. Right?
Yes.
Okay. So what we're saying, what you're saying in that report is the triggering events were at 1162, going in reverse in order. 1162 comes before 1164. They're numerical. Is that right?
Yes.
Every single key cycle just tags another number on top of it, right? There's no formula.
Correct.
After 1 comes 2, after 2 comes 3, 4, 5, 6, and then move on, right?
Yes.
So by the time you got the vehicle, there had been 1,164 key cycles on the history of that car, correct?
Correct.
All right. And you knew, and you put in your report, the triggering events that you see under 1164, those are yours. And clear that you recorded, that you talked to Mr. Lally about, were 2,
Yes.
meaning ignition cycles at least, right?
Yes.
Stated in your report, let me finish. And the triggers that occurred while testing was 36 miles. You just said that, right?
Yes.
And the key cycle difference was exactly 2 key cycles, right?
Yes.
1164, 1163, 1162. That's the triggering events, correct?
That's correct.
You also reiterated in your report in paragraph 23, 24, 26, and 29, and also in this exhibit in your CARS report, that the triggers occurred at key cycle 1162, right?
Yes.
You were assisted in your CARS report. I think you mentioned Trooper Zach Clark. Is that right?
Yes.
Trooper Proctor assisted to a certain degree, correct?
Yes.
Trooper Larini, Carol Larini, is that right?
Yes.
Also, Sergeant Sean Good of Canton PD assisted as well, correct?
Yes, in a sense.
Did they all read the report before it was finalized?
No.
Did you have any supervisor read the report before it was finalized?
Yes.
And he agreed with the assessments in the report?
Yes.
So in summary, everybody that read the report and you who authored the report believed, and it's reflected in that report, that key cycle 1162 contained the 2 triggers that you're talking about, right?
Yes.
That's the 3-point turn, I guess now a 3-point turn, right? Changing direction, and then
Yes.
the reverse at 24 miles per hour, correct?
Correct.
And you even went on and testified to that exact thing under oath in front of the state grand jury, correct?
Yes. Wait, hold on. I need the text streams?
On the key cycles.
Not in grand jury.
Okay. Testified to it on direct examination on Friday and again this morning.
Yes, correct.
If your testing occurred at key cycle 1164, that means you turned the engine on, the ignition on to start your testing, correct?
Correct.
And that triggering event that we see up there at 1164 initiated your testing, all right?
Yes.
All right. So that 1164 is where that's where there's no more unknowns, in other words. Right? You know exactly where the car is, who's in the car, who turned the car on, and what the triggering events were and what they reflected, because you did it, correct?
Correct.
It's you.
Yes.
So that would be the cornerstone, basically, of your entire analysis of key cycles.
Say again.
The cornerstone, in
Like-
other words, the one known that is immovable, it's immutable, is 1164 began your testing. Is that right?
Objection.
Is that right? I'm going to allow the question.
Yeah, that's when the car was in state custody.
All right. So starting at 1164 and counting backward, before you started your testing, you know that the SUV had to be started, the ignition had to be turned over, and it was driven to the Sally Port in Canton at 5:31 p.m. from a tow truck on January 29th, correct?
I didn't know that.
You did or did not?
Did not know that.
Okay. Assuming that the car had to be started and put on a tow truck, that would be key cycle what?
I don't know how. I can't speak to the fact that recorded a key cycle at that time.
I can't hear you.
I can't speak to the fact that we would record a key cycle at that time.
Okay. If the car was turned on and driven onto a tow truck, would that be a key cycle?
I don't know because these keys record different ways, so I can't speak to how or why it did not record on there. All I can speak to is that those are the key cycles. The odometer mileage is more what I was going after on this whole thing.
Trooper Paul, you just said unequivocally, when a car is turned on and then turned off, there's a key cycle.
I said when the car without the ignition on, that's a key cycle.
Right.
That's correct.
That's what I
Yeah.
mean, when it's turned on, when the engine turns on.
That's the definition of what it is. I can't speak to why it didn't go on, why it did not record.
Well, let's talk about the ignition cycles.
Okay.
Before 1164. Okay.
Okay.
Obviously, the car had to get to Canton PD because you saw it there, correct?
Correct.
Assume for purposes of my question, the car was turned on and there's a video of it turning on, driving up onto a flatbed tow truck.
Yes.
That would be ignition cycle. I'm going to use your word, key cycle, ignition cycle, 1163, correct?
Again, initial cycle, key cycles are two different things.
Which word do you want me to use?
If you want to talk about key cycles, key cycles. If you want to talk about ignition cycles, it's ignition cycles when the vehicle gets turned on. A key cycle does not mean to be turned on.
But every single ignition cycle includes a key cycle. You can't have an ignition cycle without a key cycle, correct?
Well, if you want to talk about it, just use the key cycles or initial cycles. I'm trying to make sure this gets out. I'm sorry. I'm trying to make sure that this gets put out the correct way.
Every ignition cycle includes a key cycle, correct?
In a sense,
By definition, it has to.
it doesn't have to. They record multiple different ways.
You can have an ignition cycle without a key cycle.
I don't know how it recorded, but it could happen.
Explain that. How could that possibly happen?
Because a key cycle is when it turns on, not engine running, and then turns off.
Okay, so work with me here.
Ignition cycle is when it turns on, engine running for 2 seconds, and then comes off.
Okay, so
Or the 2 seconds is not on long enough, it might not record one.
Okay, let's ignore the 2 seconds.
Okay.
That's not what we're doing.
Okay.
All right. Let's assume that it's an old-fashioned type of key.
Okay.
Halfway on, the electricity is on. It's like it used to be called ACC.
Yes.
accessories, Right?
Yep.
That's a key cycle, correct?
For that intensive purpose, yes. This vehicle's not a key cycle. They're not a
Then you
thing.
keep turning,
Okay.
and that turns the engine on, right?
It turns the engine on,
It's
correct?
an ignition cycle.
Yes. Well, then turns off.
Single ignition cycle necessarily includes the precursor key cycle, correct? Even though every key cycle might not include an ignition cycle. Would you agree with that?
In that scenario, yes.
Fine. Okay, with that definition, I want to talk about ignition cycles because I don't want to get confused about accessories. What? Just assume the engine.
Okay.
turns on, right?
Okay.
If you started your testing at 1164, then if the engine was turned on, thereby indicating initiating a key cycle, driving the car onto a flatbed truck, and then hauling it over to Canton PD, that would be key cycle 1163 in that hypothetical, correct?
It could be.
Okay. Then going backward from there, if the SUV was, I'm sorry, let me add one event that I just forgot. It had to get off the tow truck in Canton and be driven into the Sally Port. Did you ever see that video?
No.
Being driven in.
No.
If there was a video showing that the car was actually driven into the Sally Port, that would necessarily be a key cycle, correct?
Possibly.
Okay, so that would be key cycle 1163. My mistake, I was missing one, right?
Okay.
Before that, if the car was turned on and driven onto the flatbed to get to Canton, that would be key cycle 1162 in order, correct? We're going back.
It's possible.
All right. Before that, if the car was started and the car was driven from One Meadows Avenue to Karen Read's parents' home in Dighton, that would be another key cycle, 1161, correct?
They're possible.
Before that, if the SUV was started and driven by Miss Read from the garage at John O'Keefe's house to Jennifer McCabe's house at 5:07 in the morning, that would be another key cycle, correct? 1160. Is that right?
It's possible.
And before that, if the SUV was started and driven by Miss Read to the waterfall, I'm sorry, from the waterfall to 34 Fairview at approximately 12:15 a.m., that would be another key cycle, 1159, right?
It's possible.
I want to be clear. The reason that these numbers skip in your diagram, they don't go directly in order, right? Not every single number is in order on this left-hand column, because this is only a diagram of when triggering events occur, right?
Yes.
Something unusual about the operation of the vehicle, correct?
Yes.
And it's clear that from the data, there was no triggering event at key cycle 1159, was there?
No.
So assuming the driving events that I just told you, right? Assuming for purposes of my question, that the driving events started at 11:59, driving over to 34 Fairview from the waterfall. Then driving at 5:07 in the morning over to Jen McCabe's house, 1160. Then driving to Dighton, her parents' house, 1161. Then the car being seized in Dighton by Trooper Proctor, 1162. Then the car being taken off the flatbed and driven into the Sally Port at Canton, 1163. Your testing starts at 1164. that would mean that at 11:62, that key cycle would include the time in which Trooper Proctor had possession of that car, correct?
No.
Assuming my hypothetical,
Your hypothetical?
yes.
If that's hypothetically how it works, then yes.
Then what?
If that's hypothetically how it works, then yes.
On June 9th, 2022, you were asked by a grand jury whether you knew or had done any scientific testing to determine the distance a body would actually travel struck by a vehicle. Remember that?
Not that specifically. Not in that way.
Do you remember answering that you had not, I'm just paraphrasing, that you had not done you hadn't finished your report yet?
Why don't you show him? He said he didn't remember it that way.
Yeah?
Yes.
Take a look at middle of the page. Your answer starts at about line 12, but the question above it is probably informative. You have that in mind?
Yep.
May I approach?
Yes.
You were asked, does that remind you that you were asked by a grand juror if you could calculate how far a body would move having been struck by a vehicle?
Yes.
And you indicated, quote, yeah, there's certain calculations we can do with that, would figure out if the car backed up, hit somebody, and then they go a certain amount of distance, and it's based on miles per hour, the speed of the vehicle, the striking vehicle, and stuff. Remember saying that?
Yes.
What did you mean by stuff?
I don't know.
You said that the calculations would be based on miles per hour and stuff. Did you ever do a stuff to test that? The grand juror's question.
No, we cannot calculate anything from this collision.
Say that one more time.
We cannot calculate anything from this collision.
Who's we?
I'm sorry, me, the role me.
Well, you know John O'Keefe's weight, right?
What's that?
You know John O'Keefe's weight, 217 pounds, right?
Yes.
Did you know that?
I don't know his weight, no.
You know the weight of the vehicle?
Yes.
What's the weight of the vehicle, gross weight?
What's the gross weight?
Yeah.
I think it's approximately 7,300 pounds.
Okay. Were you able to calculate the mass of the vehicle?
I did not calculate the mass of the vehicle.
Well, you told the grand jury that you were planning on doing that kind of stuff to calculate how far a person would travel being struck at that speed with a car of that weight. You didn't do those calculations?
No, because the calculations would vastly underestimate the speed of the vehicle.
You testified, again, my report isn't done yet. I'm going to look into it. I'm looking into all that stuff, end quote, correct?
Yes.
There's that word again. It's been more than 2 years since that statement at the grand jury. Is your report finished?
Yes, it is.
Did you engage in any of those calculations?
I looked into it. This type of collision I would not be able to use the formulas for this type of collision.
Well, let's talk about those formulas. How would you calculate how far a body at rest would travel after being struck by an object in motion? How would you calculate that?
In pedestrian collisions, I use a Searle throw formula.
A what formula?
Searle.
What does that mean?
It's a type of formula that we use for a calculation of post-impact
So
or speeds for pedestrians.
that includes certain principles of physics to calculate that, right?
What do you mean?
I'm sorry?
What do you mean by certain forms of physics?
there would be physics calculations that would be required to figure out how far a body at rest would move, having been struck by an object in motion.
Right.
That's a basic principle. Of
Yeah, I guess you could say though.
All right. Can you describe for the jurors exactly what calculations you would need to employ to determine how far a body at rest would travel, having been struck by an object in motion?
So in this scenario, in this collision, it's more of a side swipe. So he did not ascertain, he did not get enough speed of the vehicle post impact with the vehicle to be able calculations. His center of mass was offset from the vehicle. So we would vastly underestimate his speed. So that's why I did not do a formula. If he was more in line with behind the vehicle, he would have been projected forward, and using that projection forward, he would have been able to get more closer to the actual speed of the vehicle during that post-impact travels.
Well, that presumes a couple of things, Paul. That presumes that he was quote unquote sideswiped, right?
Presumed?
Presumed by you. You didn't see how he was hit, did you?
Based on the evidence, it appeared to be a side swipe.
That's your opinion.
That's just reading the evidence.
You're saying that the principles of physics as we know them today in modern mathematics is thwarted by a sideswipe?
Objection.
Is that what you're saying?
The calculations that are out there, you can get a speed, it will just underestimate the speed.
You would have to know what the initial momentum of the object is that's in motion, correct?
Of what object?
The truck, Paul.
I would have to know that speed.
Yeah, you'd have to know what the initial momentum is, not speed, momentum. There's a difference,
Okay.
right? Would you agree with that?
No.
You wouldn't have to calculate what the initial momentum is of the object in motion to determine the distance of the body at rest would move?
Well, in that sense, are we talking about I'm trying to find the speed of the vehicle? That's usually what we're trying to do.
Right, okay. Well, let's put the speed of the vehicle aside. Let's talk about initial momentum. What's the formula for calculating initial momentum?
There's different types of momentum formulas.
Well, there's actually one type of momentum formula. It's to calculate momentum.
Objection.
Sustained.
To calculate momentum, there is a single.
So sustained. Ask it differently.
Isn't it true, Trooper Paul, that there is a singular calculation for determining initial momentum? That is P equals M times V, where P is the momentum. You're solving for that. M is mass. You multiply that by velocity. Is that right? Pretty simple.
You wouldn't use that in a pedestrian collision.
Oh, because the pedestrian's somehow magically out of the realm of physics?
Objection.
Sustained.
Is a pedestrian out of the realm of physics and calculations?
No, it's the weight differential between the pedestrian and the vehicle.
So if the vehicle is too heavy and the body is too light, you can't calculate the initial momentum of the vehicle?
Yes,
Got it. Where'd you learn that?
it's in my math class. Since we only use momentum for a vehicle to vehicle.
Math class?
The crash reconstruction classes I have taken.
Got it. Would you need to apply the theory of conservation of momentum in calculating these data?
Do I need to calculate the conservation of momentum?
Ever heard of conservation of momentum?
Yes,
You even know what that is? There's an equation for that as well, right?
yes.
You know what that is?
Not off the top of my head, but yes.
Based on the basic principles of physics, is the total momentum of the collision greater or less than the total momentum after the collision? Total momentum before the collision, is it greater or less than the total momentum after the collision? Basic question.
What type of collision?
Trooper Paul, they're exactly equal in all respects under the principles of physics, right? That's the theory of the conservation of momentum. Momentum doesn't change. It's just
Yes.
transferred from one body to another,
Yes,
correct?
correct.
Why didn't you say that to the jurors?
Objection, Your Honor.
Sustained.
Trooper Paul, if you were qualified to quote, look into all this stuff, you would probably know these answers, wouldn't you?
Objection.
Sustained.
Are there any other calculations that you need to figure out the stuff that you were talking to about with the grand jury?
Objection.
Sustained.
How about calculating the final velocity of the objects after the collision? Would that be important?
What objects?
That would be John O'Keefe's body, sir.
You,
Object
I don't,
that you claim was flying through the air 30 feet.
Okay,
Objection.
sustained.
How about calculating the displacement using kinematic equations? Would you be able to do that?
the displacement of the body.
In order to calculate how far the body would move based on the mass of the object striking the body, could you use displacement using kinematic equations?
So like I said before, the side swipe, he would not have gotten 100% of the vehicle, 100% of the speed of the striking vehicle. It would have vastly underestimated this vehicle. You couldn't hit a person and side swipe them, spin them off to the side, and have that and get a speed from those calculations.
So you're saying that the discipline of physics cannot figure out how far John O'Keefe's body would move, but you personally figured out that he would have flown now somewhat, or been projected somewhat 30 feet.
Objection.
Is that right?
Sustained.
Are you saying that the principles of physics are incapable of determining with the proper calculations how far John O'Keefe's body would have moved given the collision at issue?
Objection.
Is that what you're saying, Trooper?
No,
Okay, next question.
Well, you just said because it was a side swipe, all these calculations, these physics calculations are inapplicable, right?
I'm saying it would underestimate the speed and the distance.
The truth is, Trooper Paul, you have no idea what all these physics calculations mean, do you?
Objection.
Sustained.
You've not been trained in physics formally, have you?
Yes,
You have been,
it's incorporated into the classes.
right? You had a few classes that use the word physics, but you haven't been formally trained in physics, have you?
Objection.
Sustained.
You haven't been formally trained in kinematics, correct?
It's in the aspects of all our crash reconstruction classes.
You haven't been formally trained and hold no degrees in biomechanics, do you?
I do not have a degree in biomechanics.
In fact, basically what you did in this case was calculated ignition cycles. And you got those wrong, right?
Objection.
Sustained. Come on, Mr. Jackson, ask the appropriate part of the question, you'll get it.
Let me ask you this. Based on your reconstruction, nearly 2-year investigation, exactly how was that taillight shattered? Explain it to us.
How does the taillight, what do you, it gets, so the taillight in this case was shattered when it was struck John O'Keefe's arm.
Exactly what part of his arm?
Based on what I saw for his injuries was from the upper part of his arm down.
Was his arm out and it just struck the arm like a hinge? Was it in front of him? You did the reconstruction?
It looked,
Here's exactly how his body was positioned when he was struck by that.
so it looks like his arm was more kind of like this. If I can try to get that.
You're indicating out by his side, correct?
Yes,
All right. And the taillight would have struck his arm, right?
yes,
Not his torso.
yes,
Okay. So the full mass, the full weight of that truck hit him basically at the elbow. Is that right?
No,
Missing his
no.
torso.
I said it, yeah, from upper part of the arm
Right,
down.
at the
Yeah.
elbow and the biceps.
I didn't see anything that shows an indication that this lower torso was struck, but
Okay. So his
not-
torso,
it's not saying it could not have been a possibility, but I just didn't see anything.
So his torso was spared from being hit, but the arm took the brunt, the full force of the vehicle, correct?
Like arm and shoulder, yes.
Okay. And you said he then did a spin, like a sort of a pirouette.
He got spun around possibly the way it struck, it looked like it could have turned around counterclockwise.
Okay. So if he turns around counterclockwise, does Is he turning around in the air counterclockwise?
Yes,
Okay.
initially.
So he gets hit on the upper biceps, shoulder area, and down to the forearm, right?
Yes,
By an unbroken taillight, right?
yes,
In other words, it's nice and smooth. Nothing, no shards of plastic or anything broken at the time that it made contact with his arm, right?
correct.
Okay, so how did his arm get all cut up?
Because when his arm struck the taillight then cracked. And as the car is driving past him, the taillight could scratch it.
Got it. So he gets hit by the car, not his torso, just the arm. The taillight cracks, and as it passes by, his arm stays with it long enough to get striations, those scratches that we see, those lacerations. I'm sorry, those abrasions that we see, right?
In a sense, yes.
And at the same time, he does a pirouette and flies 30 feet to his final point of rest.
I don't know if he did a pirouette.
Well, I'm using the word pirouette. He spun around.
He started rotating counterclockwise. I don't know how far he ran counterclockwise, but he started rotating. According to that, would push him to rotate counterclockwise. Whether or not he went counterclockwise all the way to his back toward the ground, it seems like a most likely possibility.
Did you account for the fact that his arm is on a hinge?
Is what? Say again?
Did you account for the fact in this scenario that you just told the jurors that his arm is on a hinge?
On a
Called the
hinge.
shoulder?
Okay.
Okay, so the arm got hit. Didn't his arm just swing?
I said arm and shoulder area, so his arm could have been considered part of it.
Even if his shoulder got the upper,
Okay.
you're pointing to his upper biceps.
Mhm.
Right? There's no injuries on his shoulder, not a single one, not even a bruise, right?
Like I said, it looked like to me it was from up here. I don't know how far I can up back here, but it was up here.
Well,
So
you're the one that talked about his injuries on his arm.
yes.
That's limited to about mid biceps, about mid forearm, correct?
Okay.
Right?
Yes.
No injuries on the shoulder, no injuries on the torso, no injuries on the ribs, no injuries on the back, correct? Is that right?
Yes.
So your theory is you got hit on the arm, took the brunt of the force from the taillight on the arm, stayed with the vehicle long enough for the taillight to explode, basically, to shatter. Then these striations get on his arm, abrasions. Does a pirouette, spin, counterclockwise, and flies 30 feet in the air to his point of rest.
Yeah. Happened probably a little faster than that though.
I thought you said he hit his head on the curb.
I said that's one of the possibilities of when you look at the roadway as he gets spun around kind of clockwise, it's a possibility that the curb is there, any blunt force object on the ground, as the ground is pretty blunt.
Well, except in your scenario that you just told us, he flew through the air onto the light dusting of snow, grass, and dirt.
I didn't say through the air.
Say that again?
I didn't say he got thrown through the air.
Okay, I'll use your word. He got projected.
Projected doesn't mean it's not incorporating just throw. Project just means you get pushed forward. There's two parts of that. There's the air, then there's the ground. Like I said earlier, the tumbling, the rolling, whatever that part of the crash would happen. Projecting is just what we call what happens to a pedestrian post-impact with a crash.
Okay, so a couple questions. If his arm, elbow, took the brunt of that entire impact, how do you account for the fact that he didn't suffer a broken bone?
I don't know.
How do you account for the fact that he didn't have a fracture?
Objection.
Sustained.
How do you account for the fact that he didn't even have a bruise on the arm?
Objection.
That's sustained too.
They reproach.
Yes. All right, Mr. Lally, whenever you're ready.
Thank you. Now, with regard to your testimony, as far as that triggering event, or the two events on 12,629B, you testified that that was consistent with the pedestrian collision, is that correct?
That's correct.
Again, if you could tell the jury, why is that consistent with pedestrian?
The one specifically with the speeds and everything that we're referring to.
24.2 miles per hour in reverse for about
Right.
60 feet.
Okay, yeah, so why I think that's consistent with a pedestrian strike is because of the sudden change in the speed. It drops down by half mile per hour. The accelerator pedal is staying constant at the same percentage, and the steering wheel angle also turns to the right.
Now, your overall opinion is based on what you did as far as your construction, correct?
Yes,
Is there other information that you had at your disposal in formulating your?
like from other reports and stuff.
Yes,
Yes,
and that would include physical evidence, is that correct?
correct.
And that would include witness statements, correct?
Objection.
Sustained as to form.
What, if anything else, would that include?
The roadway evidence, witness statements.
In witness statements, would that also include statements of the defendant?
Correct.
Are you aware that the defendant indicated in a statement to troopers that she conducted a three-point turn in the area of 34 Fairview Road?
I'm going to allow that question.
Yes,
And what you observed in that triggering event is that from that mileage, is that consistent with the defendant's own statement?
yes, it is.
Now, let me ask you a little bit, if you could, again, for the jury, clarify the difference between what you termed as an area of impact versus a point of impact.
Yes, an area impact is broader. It's a bigger area. Point to impact would mean something as obviously right there. That would be the area impact.
If I could ask, the cell phone that was located under Mr. O'Keefe's body, that location, is that also consistent with the linear path that you were testifying about earlier?
Yes, it was.
And do you know whether or not that cell phone was in his hand or in his back pocket or somewhere else?
I do not know.
Now, as far as let me ask you this. You were shown some photographs of some taillight pieces near a fire, correct?
Yes,
As far as the area of impact, that was, from what you determined, that was Mr. O'Keefe's sneaker, is that correct?
yeah, it was within that. What I've had for non-initial evidence, I said the area impact was a star in that area prior to the
I'm
sneaker.
sorry,
Sorry, so what I was saying was the area impact was prior to the area the sneaker was. It was in that path, just prior to that area.
And why did you determine that it was in that area?
Because that was the first point of evidence.
And first, I'm sorry, this first point of evidence in relation to what and sort of how the evidence was configured as it was evident to you.
How was it pointed to me? It was the first point of evidence away from, the furthest point was evident at that time that knew away from the pedestrian.
May I approach the witness, Your Honor?
Yes.
Sir, I'm showing you what's been marked as Exhibit 58. Do you recognize what's depicted in that photograph?
Yes.
And Your Honor, with the court's permission, if I publish that to the jury,
Okay, what exhibit number is it?
58.
Thank you.
If you recall, do you recognize what's up on the screen?
Yes, I do.
What do you recognize that?
There's 34 Fairview to the left side, and there's the fire hydrant.
And as far as these photographs and the photographs shown to you by Mr. Jackson on cross-examination, do you know when those photographs were taken?
I do not know specifically at what time those were taken.
You don't know if those photographs were taken on February 3rd, 2022?
Objection.
Is the objection sustained?
Now, Trooper, if you could, using the laser pointer, I know you've done this on the diagram, but if you could use the laser pointer with regard to what's on the screen as Exhibit 58, direct the jury's attention to where you believe the area of impact to be between the defendant's Lexus and Mr. O'Keefe.
It's probably somewhere out here.
And as far as that linear path that you were talking about from the area of impact, where did that go from and where did that go to?
So I say, so from, I think it's around like this way.
Hey, let's go when you can take that time. May I approach this for tree count? Now, Trooper, if you could explain to the jury as far as what you were describing as Mr. O'Keefe's post-impact movement, starting sort of with the point of impact between himself and the SUV to the point where he comes to final rest on the lawn.
Yes, so he was struck along the right side in the area of his arm, and then he was, post impact with the Lexus, he rotated counterclockwise and eventually hit the ground and came to final rest.
And the ground, based on your understanding of the weather conditions, was frozen at the time, is that correct?
Objection.
Sustained. Watch the form, Mr. Lally.
Yes. So as far as anything in your testimony about Mr. O'Keefe's actions, does that involve pirouette?
No,
So there's a rotation, is that correct?
correct.
And as far as 30 feet in the air, do you have any opinion as to whether or not he flew 30 feet in the air?
I do not have any evidence that he would have flown 30 feet in the air.
And so as far as from your training experience when it comes to pedestrian collisions, are you able to determine or calculate how much distance someone is in the air and how much distance someone sort of rolls or tumbles to their final resting position?
Say it again.
From your training experience,
Yes.
based on this collision, are you able to determine how far Mr. O'Keefe was traveling in the air versus how far he traveled tumbling or rolling after he hit the ground?
I do not have a calculation for this specific style of pedestrian crash due to the side swipe. So if I did, I could use the formula. It would just vastly underestimate the speed of the vehicle.
Let me ask you a little bit about, you were talking about the Searle pedestrian throw formula, correct?
Correct.
And that's something developed in the course of physics specific to reconstruction by someone named Dr. Searle, correct?
Correct.
And that's S-E-A-R-L-E, is that correct?
That is correct.
And with respect to Dr. Searle's formula, why is that inapplicable in sideswipe collision versus some other type?
Because it takes in, it's looking for more, not so much the formula, it's how much projection efficiency that would occur, how much percentage of the speed of the striking vehicle would have happened. In order for the formula to work, the more of the body would have struck the vehicle, the more efficient the outcome would be in the speed.
In the center of mass that you were talking about, sort of in the collision sequence, what, if any, role does that play in regard to your ability to do that calculation?
It would just, like I said, it would underestimate the speed of striking vehicle due to a center mass not within the rear of the vehicle.
And not to twist your words or anything, but as far as when you say underestimate, that would not be an accurate reflection of the defendant's vehicle speed, correct?
Correct.
Now, you asked some questions about the glass and indicated that there are a number of reasons why the glass would travel with him being Mr. O'Keefe. Can you explain what those are?
Yeah, the glass could have struck the vehicle also in that same way. Could have still been attached to his hand and still gone with him in the same way. It could have been attached to his body in midair. That's the multiple ways that the glass would have stayed with him.
Now, in speaking of collision sequences, particularly collisions involving multiple vehicles, vehicles are affixed with bumpers, correct?
Correct.
What's the purpose of a bumper on a vehicle?
To help absorb the
Scope?
Yes.
Yeah. Sustained.
Your Honor, if I may, I don't believe it is.
So why don't we come to sidebar?
So I'm sorry again, Trooper. If I could ask you, what is the purpose of a bumper on a vehicle?
It's there to help absorb energy from a collision.
And with reference to the scratches that you were asked about on the vehicle on the, sort of the right rear quarter panel, what, if any, relationship does bumpers or their interaction have to your opinion as it relates to that?
Sorry, say it again.
Back to what you just testified about bumpers, you were
Yep.
also asked some questions about scratches on the right rear quarter panel of the vehicle, correct?
Correct.
And what, if any, relationship does the bumpers on the vehicle and sort of their intended purpose have with relation to the scratches that you observed?
So the bumpers on the side was more of this wasn't more of a direct on hit with the bumper. It was more of the side scraping of the paint of the bumper.
Now, the presence of Mr. O'Keefe's DNA on the taillight, is that consistent with a pedestrian collision?
Yes.
Now, as far as the glass not matching, are you aware that the lab's actual findings were that the glass on the bumper and the glass on the roadway was just not found to be consistent with each other? Is that your understanding? If you know.
I don't know.
And were you also aware that the lab's finding was that the glass on the bumper was consistent with the glass on the road?
I'm not sure what the lab said.
Now, in order to construct your diagrams, your testimony, I believe, was that you had used certain diagrams in the process of that. Is that correct?
Yes.
And if I could turn back to that 12629B, the mileage from the tech stream data.
Yes.
The 3-point turn that you observed in the 24.2 mile per hour straight line for approximately 62 feet. How far apart time-wise within that particular triggering event were those two incidents?
8 minutes.
And as far as any of the other tech stream data that you observed, was there any other triggering event that included the 3-point turn?
No.
Now, as far as the defendant's path of travel, is it your understanding that that was obtained from a multitude of different witnesses?
Yes.
Now, with reference to, you were asked some questions about the defendant's cell phone. As far as GPS locations, were you aware that the defendant's cell phone wasn't able to be accessed until by law enforcement until 2023?
Sustained.
Were you aware that the defendant's cell phone had GPS locations turned off on the defendant's cell phone?
I'll allow that.
I was not aware.
Now, as far as placing the vehicle during that triggering event, 12629B, did you use key cycles to put it back at that location at that time?
No, I didn't.
What did you use?
I looked at the odometer mileage
And why would you look at the odometer mileage over the key cycles?
because I can physically see the odometer mileage at the vehicle at the time of my inspection.
And why would, well, let me ask you this. In your opinion, as far as that is concerned, sort of backtracking to a specific location, which is more reliable, the odometer or the key cycles?
I would say the odometer mileage.
And why is that?
Like I said, you can physically see it when you turn the car, and I know that's the odometer mileage that it's reading on the dashboard.
And every key cycle, is that necessarily recorded within the text stream data?
No,
And why not, sir?
it only records stuff that related to the triggers.
They don't what?
They only record stuff that is related to the triggers.
Okay, thank you.
As far as counsel's hypothetical with regard to the key cycles, is it your opinion that that hypothetical is accurate or inaccurate?
Inaccurate,
And why so?
because you also add the odometer mileage onto the key cycle. So those key cycles and odometer mileage are on the same trigger. And plus the data seems consistent with everything else that's going on with this collision.
Now, fair to say that you were not outside of 34 Fairview Road on January 29th, sometime around 12:20 to 12:30 a.m., is that correct?
That's correct.
And so fair to say that you don't know exactly how Mr. O'Keefe and or Glass or anything that he's holding interacted with the defendant's vehicle at that time?
Objection.
I'll allow it. Is that true?
I do not.
And so based on your training and experience and the number of pedestrian crashes that you've investigated, again, if you could, one last time, just describe to the jury how you believe the vehicle interacted with Mr. O'Keefe and why.
Objection.
Sustained. It's asked and answered.
With reference to what you've described as far as the interaction between Mr. O'Keefe and the vehicle, why is that your opinion?
Objection.
I'll allow that.
Based on the evidence from the vehicle, based on the injuries to John O'Keefe, the tail light appears to be broken and it's sharp plastic pieces that could have ripped his arm, and also the dent with the scratches above it is consistent with a hand holding a glass and the glass on top smashing on the vehicle and the hand smashing the vehicle. You can see there's a line between scratches and a dent there.
And just Romeo. Very briefly, I just want to make sure I clear something up about the key cycles. You're not suggesting that every key cycle in the history of cars on this page, correct?
That's correct.
I'm pulling up Exhibit 591.
Okay.
That indicates key cycles that have triggering events, correct?
Yes.
Triggering events are something that the manufacturer includes in basically a list of items that will be a triggering event, correct?
Yes.
It's a list of items basically for mechanics to figure out if there's some unusual driving or unusual event with the vehicle, correct?
Yes.
But the key cycles go in order. They're numerical, 1 through whatever.
Correct.
And the hypothetical that I gave you on cross-examination, with those driving incidents, each one of those would represent a key cycle, correct?
So in your hypothetical, I mean, assume that it should create a key cycle, but that you can't just say that key cycle is from that, because I didn't just use key cycles. I used the odometer mileage on top of it. So you have to have key cycle and odometer.
Right. Interestingly, though, when you testified on direct examination, you said your analysis, this was on Friday, before the weekend. By the way, over the weekend, did you watch anything on, I don't know, YouTube or any social media?
No.
Nothing.
No.
No. Did you have any conversations with Mr. Lally about these key cycles and problems?
No.
Did you have any conversations with anybody about the issues with the key cycles?
No.
Did you realize at some point between Friday and today that I was probably going to ask you some questions about key cycles?
Objection.
Did you realize that yourself?
I assumed you were going to ask me loads of information.
So on Friday, you didn't mention that your analysis was based on mileage, did you?
Objection.
Sustained.
On Friday, did you mention that your analysis was predicated on mileage?
Objection.
I'll see you at sidebar.
Here come the sidebars finally. I want to thank everybody who's been super chatting tonight. Thank you, Glamour Seuss. Thank you, Suzanne. She says, "Did the Commonwealth waste 500,000 on aperture?" That is kind of the poll question tonight. I posted this poll question. Usually, I do none of the above or all the above as an option to give everyone a chance to respond. I don't like to force you to go one way or the other. But this one I just did too. I made you decide who was better, Trooper Paul or Shannon Burgess. Actually, I didn't put Burgess. I put the other guy, Welcher. Welcher's supposed to be better than Burgess, apparently. But basically, it's Welcher versus Paul. 74% of you said Paul, Trooper Paul. So he was even better than the $400,000 Welcher. Unbelievable. That's how bad the prosecution was. That Trooper Paul actually was better. This witness was actually better than Welcher, the guy they paid $400,000. Him and Burgess. Unbelievable. Good point, Glamasus. Alicia, thank you so much for donating tonight. Super Chat says, "I love your X account." Talking about our guest tonight. She was great. Thank you so much for being here for
Yeah,
attorney
Yes.
Corri Hopkins tonight. That was great.
You indicated pretty clearly that your analysis was based on the key cycles, starting at 1164 when you started your testing, and 1162, which was the key cycle you claimed on Friday was at 34 Fairview.
It wasn't based on it. That's how I describe it. I said key cycles. I based it on they were close within proximity to each other, but I've always said it's key cycles and odometer mileage, plus all the information within the triggers themselves. So it wasn't just one of the other.
And you said on Friday that once you started your testing in 1164, it was 2 cycles earlier that had the triggering events, meaning 1162, that you claimed were at 34 Fairview.
Yes.
But in the hypothetical,
Funniest thing too, the reality is that Welcher got paid a lot more than Trooper Paul. Trooper Paul was actually better, and we all think that Trooper Paul should probably get demoted somehow, but he's actually worth the money, it turns out, compared to their other witnesses. This is just, what's great about watching this video, why I love playing these old court videos now. It's just so much more enjoyable, more relaxed, just to watch this video, because there's not that stress of having Karen Read's life be at stake. It's much more pleasurable to watch this now. And I think we're just going to keep dripping these. We're just going to keep watching these forever. Just watch all of these videos that we have forever.
if there were 4 events, 4 key cycle events between 1164 and 1159, it could not have occurred at 1162, correct? 34 Fairview, in my hypothetical.
In your hypothetical, if it recorded a key cycle, then your hypothetical is correct.
Right. And last question, if you got the route of travel incorrect, if your presumption of the route of travel was incorrect on that vehicle.
A great comment. Mazza made the comment today. He said, "You know where I could get $1 billion? You should ask Ron Marano at the State House." That's what Michael Morrissey did. That's another leak that came out this week from the emails from the Foyers. I'm not a mute. I'm not muted. How am I muted? I'm not muted. Am I muted? No, I'm not. I don't know. But anyways, Michael Morrissey, Did he get the million? I don't know. He asked for it. We don't know if he actually got it. We know tonight we talked about it with Nanya, with Corri Hopkins. He went to asset forfeiture. That's how he funded apparently Aperture, but we don't know if he actually got the $1 million from the Massachusetts State House. He did request it. We don't know. We haven't gotten everything. That's the thing. We get these leaks of these emails. It's so funny because you see Meredith asked for a bunch of emails. Meredith O'Neill, she posted what she received. It was all a bunch of gobbledygook mostly. There was nothing really there. There was a couple things, but not much. And then NBC gets their bunch of emails. Jessica Machado has a friend who got a bunch of emails. So we're getting different things from different people. Yeah, see, it wasn't me. It was Sarah. It was my mod. Sarah, you're now you know how it feels, Sarah. It was Sarah. Oh, Sarah did it. She did it to herself. That's usually what I do. I'm pretty good with the mute. This new microphone, people say it's not loud enough. I have it turned up blast, like on full blast. I could look at the gain. I don't know if that's the issue. Maybe maybe I do need a new mic. I don't know, but it's easy. The reason I like this mic is because I don't mute as much. It's the button's right in front of me. I can see it. Like if it's blinking, I'm not looking over to the side. So I notice it if I'm on mute. That's why I'm not on mute as much anymore. But yeah, I think it's fine. I was listening back tonight to it on YouTube on my phone. With my phone has the worst volume without speakers, and it sounded fine. Like the interview, people are like, you need to turn up your volume. I'm like, sounds fine to me on my shitty phone. I think you guys just want me to perform circus acts for you, and I'm done with that. If it sounds good to me, it's good enough for you.
In the days earlier, then your mileage would be incorrect also, correct?
Mileage from what? The odometer or from
The odometer reading.
the odometer reading? Is the odometer reading? It's 36.
My point is, your analysis that's based on the odometer reading, 36 miles here, 12 miles there, 2 miles here, 5 miles there. If you got the route of travel wrong and the route of travel was different, your assumptions about the odometer readings would be incorrect as well, correct?
So what I'm
You got the path of travel wrong.
so what I purposely put down a range on my Google images shown because I couldn't tell you her definitively route of path for every single way, but I know that it's possibly a possibility that she could travel 36 miles within those locations that she traveled post leaving Fairview Road.
Or if that mileage was put on at key cycle 1162, then that would mean that would be the vehicle would already be in Massachusetts State Police custody, right? Into the proctor's custody.
Objection.
So that's beyond the scope.
That's all I have.
All right, Mr. Lally?
Just very briefly. The range that you came up with for the defendant's path of travel, does that fit with the path of travel, the odometer reading, putting the defendant's vehicle in the area of 34 Fairview Road when it does the 3-point turn, and then 8 minutes later when it travels 24.2 miles per hour in a straight line in reverse for approximately 62 feet?
Yes.
Nothing further.
All right, you are all set.
Thank you, Your Honor.
It's funny how she just saved his ass right there at the end with Jackson. It's beyond the scope. It's beyond the scope. It's so much easier to watch now. So much more fun. Thank you, Kat. I think I thanked Kat earlier. And thank you, Jersey Jen. And thank you to our new and recurring members tonight. We got some new ones. Thank you, Nick Starrow. Check out his channel. A lot of fun. I like he's a labor attorney. He's phenomenal. He's fun. Check him out. Glam Suze, I said thank you. And especially thank you to Sarah for the Young Jerks memberships. And thank you, Jen O. I saw her tonight. MJ. Love to MJ right now. All right, I'm going to head out. I'm not sure when I'll be back, but I'll be back. There's a lot going on this week. Tuesday and Wednesday, there'll be court hearings. I'll be trying to stream those, obviously. And Yeah, and one thing, I got a special announcement. Special announcement right now. I haven't received any paperwork from Attleboro District Court, um, despite being reported by Grant Smith Ellis and the Krusty Panties lady, who said they reported me to the court and that I was going to get in big trouble and I'm an idiot and all this other shit. Nothing's happened, which is what we all expected. Just funny. It's hilarious. I win again. I win again against these fools. All they did was get us more attention and more subs. Thank you so much to Grant Smith Ellis and the Krusty Panty Lady for helping us have a big show earlier this week when that judge just kind of made a hissy fit, and then these people tried to be little snitch selves. After KP said that she wasn't snitching me out, she snitched me out again and lost. It's hilarious. It's just so much fun to watch them lose. They always lose. Music to my soul says Welcher was more qualified, but that made the fact that he refused to do real testing even more glaring. He was afraid it would disprove the Commonwealth case. Yeah, I think that's why Welcher loses tonight, right? And to look at the results of the trial too. Like trial one was hung, right? Well, if you agree with the results of trial one, I don't even think it was hung trial one, but trial one, I think actually Lally and this clown tonight, as bad as he did, Paul, did actually slightly better than the Welcher crew with Brennan. And you guys agree tonight, 70+%. That's overwhelming. All right. So I'm going to head out. I want to thank everybody for being here tonight, everyone watching. Thank you, Sarah, too, again, for the memberships. I love she did the memberships at the end of the show when the diehards are still here. That's like the best time to give them, versus when it's a huge show and we have 10,000 people here when, sometimes that happens here. I gotta say too, I've taken a little bit of time off, taking it a little slower, and I'm enjoying it. But I'm also enjoying coming back. I've enjoyed some of the shows we've been doing lately. Ever since the Brad Radley show, that was fun with Amy Bradley. It's fun, not that fun because you're obviously talking to a family member that's going through some rough times, but fun to find another cause, another issue that you want to support, another group of family to support, and it's been good to get back into it, to do some shows over the last couple weeks. So definitely going to come back and do more shows. It's been nice to kind of ease up after all we went through with Karen Read, but there's a lot more happening and we're seeing it all the time. So we're going to be here, and this week definitely we'll be covering it. Hope to see you. Make sure you're checking us out every night. Just check back on our Twitter or our Facebook or especially YouTube. We always do schedule usually at least an hour before, sometimes a couple hours. Usually if, we're going to do a show that evening, we usually do it that time, during the day sometimes. So make sure you check it out. Sure there'll be some shows this week. Yeah, Tuesday is Mile King and Wednesday is Aiden. We'll definitely be covering those. Tuesday morning and Wednesday. All right. I'll see you soon. Thank you, everybody. Have a good night.